Good morning. Welcome. The board has convened a hearing today in the case of Arkansas Electric Cooperative Corporation, petition for declaratory order and finance docket 35305. This case has drawn a great deal of interest, and as a result, we have several panels of participants who will be speaking today. A list of participants, together with their allotted times, was issued by the board in our July 21st, 2010 decision in this case and is available at the back of the hearing room. Before we begin with the presentations, I wanted to cover a few procedural matters. We have asked each party to present their comments as they deem appropriate, but participants should be prepared to answer questions from the board after allotted time. We have read the pleadings and evidence submitted into the record, and while there is no reason to repeat every point, we hope that you will focus on drawing our attention to those aspects you believe are most salient. Speakers, please note that the timing lights are in front of me. You will see a yellow light when you have 1 minute remaining and a red light when your time has expired. The yellow 1 minute light will be accompanied by a single chime. The red light signifying that your time has expired will be accompanied by 2 chimes. Please keep to the time you have been allotted. When you see the red light and hear the double chime, please finish your thought and take a seat. In addition, just a reminder to everyone to please turn off your cell phones. Now we'll proceed. Any opening statements?
Very, very briefly, it's a very important hearing we're going to have today. We have some very detailed presentations, very technical presentations. Many consultant verified statements and studies have been submitted, and so it's obvious that a lot of time and effort has been spent on this issue by both the railroad and by the shippers. One issue that I hope that will be further fleshed out during this hearing is the IDV .2 standard itself, in terms of how it was developed, what it measures, how it can be verified regarding its accuracy and integrity. I hope that the parties will address this thoroughly in their presentations and in the responses to questions from the board. Thank you.
Thank you, Vice Chairman Mulvey. Anything from each?
I have no opening statement.
I have none either. So we will proceed. We will call up the first panel, which is the government panel in the United States Department of Transportation. You may proceed, Mr. Smith, and you have 5 minutes.
Thank you, Chairman Elliott. Vice Chairman Mulvey, Commissioner Nottingham, my name is Paul Samuel Smith. Again, it is my distinct privilege to represent the United States Department of Transportation. With me is Dr. Ted Sussman from the Department's Volpe Center in Massachusetts. I brought him here not to make a presentation, but to answer any questions you might have of a technical nature. He is an expert in rail ballast and track geometry. He was very closely involved in those portions of the department's submissions on that subject, and I would be utterly at sea if I tried to answer any technical questions of the kind that the Vice Chairman might be interested in, but not Dr. Sussman. Thank you. And I want to leave you today with a few main points, and the first one is indeed, as the doctor will get into if necessary, that coal dust is a particularly pernicious fouling agent. It is not a garden variety dust or a fouling agent. It has its own particular characteristics, particularly when wet. It is something that poses a particularly substantive problem to the stability of rail ballast, and although there has been some doubt raised on the record, we don't want there to be any doubt that from the FRA's perspective and from the DOT's perspective, it is a real substantive problem that must be dealt with. Having said that, it is also the case that from a safety perspective, there is more than one way to deal with it. There is indeed maintenance, accelerated maintenance, expanded maintenance, and that has been going on in the Powder River Basin since approximately 2005 anyway. There are also other methods, containment type methods, that stop it from being released in the first place. From a safety perspective, from a compliance with FRA ballast standards perspective, either will do, and we want to make sure that you recognize that there are multiple choices, and indeed other countries, other shippers, railroads, government agencies have taken different routes, have indeed, at least in Australia, taken the route that we at DOT prefer and that the board has preferred usually as a policy matter, and that is a cooperative effort on behalf of all concerned, and not just the railroads, not just the shippers. Those parties have an identity of interest, so that kind of alignment, it provides the best incentives, we think, for progress of a cost-effective nature. And in adversarial proceeding, unfortunately, there's most often a winner and a loser, and it's much more difficult to get a cooperation in that context. In this case, of course, BNSF's tariff rule has put the containment option before you, and as a result, under Section 49 U.S.C. 10702, that must meet the standard of reasonableness. Reasonableness, as in this case, means that you must be satisfied with the bona fides of the methodology chosen by BNSF to arrive at its emission limits, and there are, of course, two different ones for different lines, and at the results that can be anticipated from having met those limits. We do not take a position on those highly technical matters, but we think that that's what the law requires. We do believe it is certainly appropriate for the shippers to load their shipments in a manner that every other shipper does, to our knowledge at least, and that is so that it stays in the transport car, either because in other cases it has its own inherent value, or because there could be operational or safety problems if it gets out. I want to just leave you with one last point, and that is that FRA will continue to oversee the safety of the operations in the Powder River Basin and elsewhere. And I left with you a copy of the preliminary National Rail Plan. It's a public document. I'll leave one here for the record and provide you with an electronic copy if you like that. On page 4, there is a graphic, figure 1, and it shows traffic density, traffic volume. And you'll notice right in the center is the bright red. It's the highest volume traffic corridor in the country. It's coming from the Powder River Basin, and it meets up with other lines after that. So this is an extremely important line for energy purposes and every other. Thank you very much, and I'm standing ready to answer your questions of a non-technical nature, and Dr. Sussman is here for those.
Thank you very much, Mr. Smith. We really appreciate you coming here today and providing your expertise. The one question I had is more of a broad question, and it might go to the doctor. With respect to, in 2005, we had these derailments, which were quite serious, and the allegation is that it was as a result of, partially as a result of coal dust. And I guess my question is it only happened from my understanding in 2005, and why all these years, for hundreds of years, coal cars have been running, without any type of containment, and why all of a sudden 2005 has it become such a big issue? If any of you had such a thought on why that is the case.
I could speculate, but about volumes and such, but prefer not. Perhaps Dr. Sussman has a thought.
For the most part, I think the Powder River Basin has come into large use because of regulations on the quality of coal used, and that has concentrated the source of coal to the Powder River Basin. But I think BNSF would be a better answer to the direct questions of the volumes on those lines.
Thank you. And one other question, with respect, you mentioned cooperative efforts, which I always encourage. Have there been anything similar to a cooperative effort on issues of this nature, maybe at the FRA or DOT before?
Not at DOT or FRA to my knowledge. I think I would have learned of that in the process somewhere in this proceeding. About coal dust, of course, in the record, there's references to cooperative endeavors either at one point or it's still ongoing perhaps with different railroads or in different places, but that's all I know about this particular subject.
Thank you. Vice Chairman?
Thank you. About the coal dust, isn't it true that Powder River Basin coal is different than, say, a Appalachian coal or Illinois coal, and that the dust is finer coming off the trains from the Powder River Basin?
My knowledge is limited to a very basic level, and that is it is different in terms of the energy that it produces and in terms of its what is emitted when it is burned. But beyond that, perhaps Dr. Sussman knows.
Dr. Sussman?
I believe there is a difference in the amount of dust. It is a finer dust, and it's more prevalent.
Yeah, we had some examples the other day. We were looking at the Powder River Basin coal in a test tube and Appalachian coal, and clearly the Powder River Basin coal did seem finer than the Appalachian coal. I want to make a small point on this graph, since this has been very, very contentious around here. This graph of the forecast of traffic volumes is based upon the freight analytic forecast, is it not?
I believe that's the case, and that is not just rail traffic. That is all modes.
But you are aware also that we did a study here at the STB by Christensen Associates, which was done subsequent to this, and really questioned the accuracy of this flow, especially given the turndown in the economy that's occurred since this was first developed, as well as some of the other projections with regard to coal traffic that were made by the DOE.
There's no question but that the economy has had an effect on pre-recession projections. This particular graphic is drawn from information that it's listed as 2002, but I've been assured that at least with respect to Powder River Basin coal volumes, those have not declined at all. There has been some reduction, of course, again recently with the recession, but in terms of the relative dimensions, this is still the largest, heaviest volume rail line in the continent of the world.
One question for Dr. Sussman on this issue of the measure, the IDV.2, 0.2, whatever it is. Are you familiar with what that stands for? How it was developed? Is it parts per million? Or what is it measuring? And are you confident in the techniques that were used to develop these measures?
I don't think that Dr. Sussman is. He has reviewed the verified statements and so forth, but that's the extent of his knowledge at this point.
I don't have any other knowledge than what's in the record.
Well, it's a proprietary program, I gather, but it makes it difficult to evaluate whether or not it's appropriate or not. And but we'll develop that later. Thank you.
Thank you, Vice Chairman. Commissioner?
Thank you, Mr. Chairman. Mr. Smith, thank you for being with us today. It's always good to have someone from the department before us. Just a couple questions, if I could. One of the advantages of having the department participate is we can perhaps learn something about how other modes of transportation handle issues such as spillage, lost cargo, and steps reasonable or unreasonable to prevent spillage and lost cargo. Can you help educate us? Are there other modes who have taken steps or do take steps routinely to prevent cargo from being spilled or lost during transit? I mean, I can just think for example, as a customer occasionally in my private and sometimes on business capacity of the commercial airlines, if I were to arrive and try to check in a shopping bag that was ripped and leaking clothing or other material at the counter, I probably wouldn't be able to check that bag. That's it may sound like a very pedestrian example, but can you help fill us in? We know that a lot of coal, for example, moves by barge, truck. Have those sectors and modes been able to contain routine spillage?
Well, other than, of course, hazardous materials, which are very heavily regulated in terms of their packaging and so forth to prevent that from happening. The only other comparable mode of transport of which I am aware, although you mentioned barges, they go down the riverways, they are not covered, but they're not, unless they actually, unfortunately, have an accident, they're not subject to the kind of jostling that rail motions subject their traffic to. And the only other remotely comparable transport mode that I'm aware of are in the large dump trucks, which of course in recent years have had to have covers installed to prevent loose shipments of gravel or coal perhaps, and for short distances and so forth, which historically was not the case but has been in the last decade or so. But beyond that, there isn't a problem that I'm aware of with more or less consistent spillage, simply because the shippers and the receivers would have a real problem if there was. Now that, again, for 100 years, that hasn't been the case with coal. I'm not exactly sure why it is that it's just been accepted as a byproduct of coal transport for so long.
So in your professional opinion, would you say it is unusual or the opposite? Does it fall within the norm for common carriers or a common carrier to routinely or to have routinely allowed for the spillage, routine spillage or routine loss of common carrier cargo?
I don't know of any other instance where that's happened across any mode.
Do you have any testimony for us about just the reasonableness of a common carrier wanting to adopt, if it were the case, and we'll explore this later today, I certainly will, if a common carrier wanted to adopt a no cargo loss policy, would that generally sound reasonable or unreasonable? Basically, we'll get you you pay us to deliver stuff, whatever that stuff might be. We'll guarantee to the best efforts we can that all the stuff you ordered you'll actually get. We won't lose any of it on the way. Does that sound reasonable to you or unreasonable?
I think as a general proposition that's probably reasonable, and I think it's probably the norm, as I said, in other modes of transport, and even in this mode for more or less every other type of shipment that there is. Now, obviously, given the extraordinary volumes of the coal traffic and the unit trains and the distances they travel, a lot more than your I guess standard concerns, your standard logistics would be required to ensure that that happens. But and of course the nature of the cargo itself is not quite powder, but it's quite granular and small. It's not prepackaged in any way, so like or in an enclosed container like a boxcar or a grain car or something. So it's you'd have to go about, especially with the backdrop of nothing at all like that with coal transport by rail. You'd have to maybe not invent the wheel, but you have to bring it over from other contexts here it's an extraordinary and extraordinarily important traffic.
The point you make about all other commodities moving basically in a manner that prevents the routine spillage or loss of that commodity, I think that's an important point. It seems to me, and perhaps the department has a good sense of the history of freight transportation, that it probably, I don't know this from personal observation, but I'm surmising that perhaps every other commodity that today moves in a no routine spill manner, somewhere along the line historically actually made some adjustments or made some car standard adjustments to get to that state. I'm guessing that when railroading first started in the 1800s, you probably had a lot of stuff moving on pretty simple cars, exposed, open, spillage, loss of grain or grain damage, for example. And over the years, the industry working with its customers seems to have adopted ways to ensure that those other commodities actually get to their endpoint destination without routine spillage or loss. And presumably those railroads and their customers have had to absorb over the years the costs of those technology improvements, those container improvements. Do you know anything, what happened with coal to make that the exception?
No, I'm personally not enough of a historian for that, as we recognize in our position papers. We're not aware of this happening anywhere else, and we don't know why it happened for so long with coal. I'm not sure. Obviously, circumstances have changed, we now recognize that it's not just a low-value commodity that has no consequences when it does get out in volume, especially, and perhaps that's part of the reason that it didn't appear on anybody's radar screen, if you will, for decades. People didn't recognize it for what it actually was, at least in certain circumstances. That's all I can speculate about myself.
I know we'll hear some conflicting, as we often do, and that's one of the good purposes of a hearing such as this. We'll hear some conflicting arguments about the relative hazards or negative externalities of coal dust. Some of the submissions to us indicate or argue that it's somewhat benign and can be addressed with just simple routine maintenance. Other testimony says coal dust is a much more serious problem. Putting that aside, even if we were to stipulate just for the moment that coal dust was benign, that it had no harmful effects on anything, hypothetically, I'll just ask you, couldn't a common carrier be within the realm of reasonableness by just saying we want to guarantee that all of the cargo you asked to be shipped to you actually gets to you, even if it's cotton candy or peanuts or coal or widgets, that we won't drop it along the way?
I see two kind of countervailing strains in that. The first is, yes, of course, that makes sense. The second is, under the legal standard of reasonableness, the cost-benefit analysis that one goes through to determine what's reasonable, it may be very expensive to prevent cotton candy from falling out of an open rail car, but if there are no implications for operations or safety or something like that, which again perhaps is why coal dust has been left as it has been for so long, then how reasonable is it to enforce a containment strategy of one sort or another that would be more expensive and not reach the level that, because there's no benefit to be attained. If there's no consequence for the cotton candy or whatever coming out of the car, then what is the benefit to closing it, except for, again, this kind of common sense principle that, of course, whatever it is that's being shipped should stay in the car in the first place. I think that's a fallout of the reasonableness test and the adversarial proceeding that brings it to you today and other occasions.
Okay. I'm not sure if that passes my leaking luggage at the airline counter test. I would hazard guess most of the
Assuming
time.
there's no security question about the leaking luggage these days.
The reality is
that would be an airline or maybe a TSA kind of policy as opposed to a DOT nationwide standard that thou shalt not bring leaking luggage on aboard your carry-ons or something.
I'll wrap up in a second. Thank you for forbearance, Mr. Chairman. Have you had a chance what we really have at issue here today when we boil down what brought this hearing together is, of course, a specific tariff that was drafted and imposed by the BNSF. Have you had a chance to look at that tariff and the terms that touch on coal dust?
I know that there are quantitative limits, one for each of the two lines that are at issue, and I know that they are designed, according to BNSF, to prevent the emissions, or a very, very high level of the emissions. But beyond that, that's why Dr. Sussman and others provide the content of our statement, and why even then, to make sure that you knew that as far as we are concerned, coal dust is indeed quite pernicious. We couldn't and don't take a position on the scientific bona fides of those particular limits.
If I were to sort of simplify down or strip down to sort of layman's English the terms of the tariff and describe it as follows, your coal car's rail customer better not leak significant coal dust or else, and that phrase were put in the tariff. Would you not have some sympathy with the rail customer's concern? Well, what is or else mean? In other words, coal dust has been falling off of rail cars for hundreds of years, and now we're being told, the rail customer being told, stop it or else. As you look around the different modes, and there are all kinds of requirements about transport, including the examples I raised about commercial aviation. There's certain things you can do or can't do to make yourself eligible to actually board a commercial flight. But usually you're told somewhere in specific terms what those terms are and what those repercussions are. Do you have anything to say about sort of the reasonableness of the rail customer's expectation that they actually be told in advance of entering into a commercial relationship what the essential terms and conditions are in some detail?
Well, indeed, the shippers have raised that. It is a very legitimate question. In its rebuttal filing, BNSF seemed to put a different emphasis on the standards themselves and how it and what it's going to use them for. In other words, it's a tool, it's a prod, and they just want, according to the rebuttal statement, to begin to see some progress to deal with this problem on the containment side, and they are going to accept good faith efforts. So it was, to me, an added element of flexibility, perhaps because this standard is, even the IDV is a new term, and the standard is new, and as you said, has gone on for decades without anybody paying much attention to it. And so it may be that it's a recognition that a hard-edged standard maybe isn't appropriate at this time, but I'll certainly leave that to them. But yes, the shippers certainly have a legitimate point to know, to the extent that they can, or that BNSF can tell them, the or else. And that is, I think, a legitimate part of your inquiry as to whether the overall rule is reasonable. Because if the rule is not going to be enforced, then why bother in the first place?
Thank you. I have no further questions for this panel.
Just a bit of a follow-up on the question that the Commissioner Nottingham had raised earlier, and that is whether or not there's any other modes of transportation where this problem exists. And what comes to my mind is that there has been a problem with fugitive dust in the past from trucks carrying municipal solid waste to landfills. And I believe that those problems have been addressed by local municipalities, putting restrictions on the trucks and requiring the trucks be covered in such a way that they avoid putting out fugitive dust. But I believe that's a local issue, and therefore does not involve interstate commerce usually, and so therefore the department was not involved. Do you know anything about that particular issue?
I do not. I don't believe the department. I agree with you. I don't believe the department was involved. I can't say definitively it was not. It sounds to me more like either a strictly local matter or possibly within some kind of overall program or guidance from EPA or another environmental agency at the federal level.
Or perhaps state environmental agencies.
Indeed.
The other thing is, and this is an interesting issue, because the shipper and the loader are not the same individuals or the same firms here. The shippers are, in fact, the utilities. The loaders are the coal mining companies. Does that pose? Have you looked at that as a problem, and how that could be addressed? After all, it's some of the proposals for correcting this, spraying of surfactants or loading the car, profile of the load be done in such a way as to lessen the likelihood of dust emanating from the cars. These will be the responsibility of the coal companies doing this, and yet the penalty goes to the shipper, who has very little control over of what the coal company does. Do you have any views on that?
The mine owners have been conspicuous by their absence in this proceeding, and that may be because that, again, traditionally all they've ever done is load the cars through more or less, I guess, standardized chute. I know that they have been more recently involved in changing the profile, if you will, of the coal. Obviously, to the extent that there would be some kind of containment strategy, whether it's surfactant spraying or coal car covers of some sort, that changes to some extent the logistics of the loading, possible, and if it's depending on what it is, the unloading, possibly the burning of the coal. I don't know what surfactants do to the characteristics of the burn, whether they do anything to the inside of the cars that are used, if they're in fact made to keep the coal in the car, then I wonder what that does to tipping them over when you get to the utilities. I know it's not going to hold several tons, obviously, but I just wonder the implications. That's part of the inquiry here that I'm not familiar with. That it may be that somebody's addressed that in the record, and it may just be that the mine owners will certainly be cooperating with their customers, and they recognize their customers for the most part are quite some distance away. But as to who is to bear what part of a corrective measure and the cost of that, again, the containment obviously has to be at the mine if that's the route that is gone, and if it's after the fact maintenance, then that just occurs elsewhere on the line.
Thank you.
Thank you, Vice Chairman. Thank you very much, Mr. Smith and Dr. Sussman. We greatly appreciate you taking the time to come and help us out in this very complicated and interesting case. Free to go.
Thank you very much.
Next, we'll call up the second panel, which are the carriers, BNSF and Union Pacific. We'll have BNSF start out. You have 30 minutes, and it looks like later on 10 minutes on rebuttal.
Thank you, Mr. Chairman. My name is Rick Weicker from BNSF Railway. There are three of us that are going to make statements on behalf of BNSF and to some extent some interplay. On my left is Mr. Greg Fox, our Vice President of Transportation, who will explain why the coal dust problem in the Powder River Basin must be addressed by keeping coal in the cars and not performing after-the-fact maintenance. Mr. Sipe, on my right, will address the legal framework for assessing the shipper's claim that our coal dust standards are unreasonable, and also summarize some of the evidence that supports our challenge standards and some of the issues that have just been raised about the development of our standards. And I will address some of the issues about how we anticipate achieving compliance with these rules and our efforts in that regard if this rule is permitted to go into effect. As we've described in extensive evidence, we are asking the board to conclude three things. It is necessary to keep coal dust from blowing off loaded cars in transit, and that's important for a lot of good reasons. Second, we believe as the operating railroad, we have the authority to issue rules, such as at issue here, that promote safety, reliability, and efficiency, and do something as fundamental as say the commodity should stay in the cars. Excuse me. And third, we ask that the board conclude that these standards, which have been the product of years of research and work, are not unreasonable as they stand today. I'll turn it over to Mr. Fox to describe the background.
Very good. Good morning. I am Greg Fox. I'm the Vice President of Transportation at BNSF. My team is accountable from that perspective for our train network, the operation of our train network. Just prior to this position, I was the Vice President of Engineering. My team at that time had accountability for the maintenance and reliability of our physical infrastructure, and I was in that role in 2005 at the time of the back-to-back train derailments on the joint line, and I played a key role in the extraordinary recovery efforts that we put in place after that incident. I therefore speak about coal dust from both the perspective of track maintenance and the trains that run across that track. And clearly, based on my experience, coal dust cannot be allowed to continue to be deposited along the right-of-way. Coal dust compromises the strength and integrity of the track structure, and frankly, it puts at risk the transportation services in a critical part of the overall nation's energy supply chain. Shippers must be required to take the measures necessary to keep coal dust in the cars. The evidence in this case shows beyond really any question that coal dust fouling along the right-of-way on the joint line is extensive. As you can see from these photos, coal dust fouling is not confined to a specific location. Coal dust is found all along the joint line. Witnesses have also explained that coal dust is not confined to the joint line alone. There's a very high volume of coal traffic on lines leading out of the joint line, and extensive coal dust deposits have been found along these lines as well. Coal dust has been found along BNSF right-of-way as far as 500 miles from the joint line. There also can be no question that coal dust comes off the top of loaded coal cars in large quantities, as shown in this short video clip. This photo shows the top of a loaded coal car and the effect that wind erosion has on the load. Coal blown off of the car, along with coal blown off of the thousands of other loaded coal cars on the joint line, is deposited along the right-of-way and ultimately makes its way into the ballast section. Coal dust emissions on the joint line were manageable in the early years when transportation volumes were relatively low, but the joint line has become, as indicated earlier, the most dense rail corridor in the world. As many as 70 loaded coal trains move on the joint line each day. BNSF estimates that up to 500 pounds of coal may be lost from the top of each car. If we assume that each of those 70 trains has 120 cars, that adds up to over 2,000 tons of coal dust deposited on the joint line every day. BNSF became concerned about coal dust as volumes increased, and after our initial study of the problem in 2003-2004, we concluded that measures needed to be taken to address the coal dust emissions. We accelerated our study of coal dust after the May 2005 back-to-back derailments, and after 5 years of cooperative study, the evidence is overwhelming that it's time to take action. It's time to keep coal dust in the car. In my personal opinion, doing nothing is not acceptable. Shippers have argued that BNSF should be required to deal with coal dust through expanded maintenance after the coal is escaped from the cars. This is an irresponsible position for them to take. This slide shows a cross-section of railroad track or road bed, and the principal purpose of the ballast section you see here is to anchor the track and to provide resistance to the movement of ties and rail. Also, the ballast section bears and distributes the applied load of the train, dissipating that pressure to the subgrade and the earth below. Finally, the ballast section is accountable for drainage, providing drainage. We also use it to facilitate track maintenance and surface the relationship between the rails. As indicated earlier, coal dust is one of the worst fouling agents of the ballast section. Studies by the University of Illinois and my own experience show that its characteristics make it particularly dangerous for track stability, even in small quantities. Shear strength is a key component of ballast performance. Shear strength occurs when friction is created when one piece of ballast contacts or interlocks with another piece of ballast. Shear strength is the characteristics of compacted ballast that allow the ballast section to distribute that applied load of the train to the subgrade below. As you can see on this slide, when coal dust fills the voids between the individual ballast pieces, friction is lost, shear strength is lost, and the support for ties and rail is adversely impacted. This leads to deviations in surface or the relationship of the rails to one another, and if left unattended to, can result in service interruptions. This situation only gets worse when coal dust gets wet. Routine maintenance cannot deal with the large quantities of coal dust along the joint line. One of BNSF's engineering consultants recently estimated that more than 1.58 million tons of coal are deposited along the right-of-way on the joint line, not counting the coal that's already in the ballast section. In 2008, BNSF did a very limited cleanup of coal dust around waterways, and we deposited over 300 rail cars of coal dust. We removed 300 rail cars of coal dust. 1.58 million tons shown on the previous chart would equate to 14,000 rail cars of coal dust that needs to be removed from the joint line. Obviously an extreme condition. Given the high level of coal traffic on the joint line, it's not surprising that coal dust accumulates far too rapidly for routine maintenance to keep up with it. Here's a picture taken in May of 2007 of a section of the joint line that was constructed in the fall of 2006. From this, you can see rapid accumulation of coal dust. Coal dust also does not accumulate only in visible deposits along the right-of-way. It also accumulates inside the ballast section. This photo shows coal dust fines being removed or extracted from the ballast section by an undercutter, which cleans the ballast. We are currently undercutting track on the joint line at least 2 times more frequently than what would be required under non-coal dust conditions. Even with this extraordinary amount of maintenance, it's not enough. Coal dust, even in small amounts, poses a real threat to the integrity of the ballast section and track stability. After the fact, maintenance is absolutely not the answer here. Coal dust deposits are too voluminous and widespread. Maintenance will never be as effective as keeping the coal dust in the cars to begin with. Coal dust accumulates in the ballast section are not always possible to detect, thus making it very difficult to know when and where to do corrective maintenance. As you can see from this photo, ballast appears to be clean, often has coal dust beneath the surface. At the end of the day, with the right confluence of events, and with coal dust in the ballast section, there's a very real risk of a service interruption taking place. That's a risk that BNSF is not willing to take. When maintenance activity takes place and takes tracks out of service, particularly on lines outside of the joint line where we don't have double track or triple track or 4 main track capability, in those single track locations we hold trains for maintenance windows several hours, or in some cases we reroute trains around those maintenance windows. This map shows the lengthy reroute of coal trains that were destined for the Memphis Gateway. We were rerouting trains around an extended maintenance window near Lincoln, Nebraska, adding several hundred miles to the route of these trains just to make time available to address coal dust caused maintenance. Our engineers estimate that as much as 80% of the slow orders and the maintenance windows on the Powder River Basin are driven by coal dust. After the fact, maintenance also does nothing to address the effects of coal dust that's blown off the railroad right-of-way. This photo appeared recently in a Nebraska newspaper of a local organic farm that was severely impacted by coal dust washed onto the farm. Expanded maintenance would do nothing to eliminate the nuisance caused by coal dust. BNSF's concerns about reliability are clearly not hypothetical. Coal dust was absolutely a contributing factor in the back-to-back 2005 derailments on the joint line. We have expanded our efforts to deal with coal dust since then, but again, given the high rate of coal dust deposits, the uncertainty with which accumulations occur, and the risk that ballast fouling may go undetected, it is not possible to eliminate the risk of another service interruption. At the end of the day, BNSF's not willing to take that risk and the potential threat to the supply chain. The best place for coal dust is in the rail car. There's no other line of business where we allow the product that we're transporting to fall off the car. Thank you.
Good morning. I'm Sam Sipe. As Mr. Fox explained, BNSF has concluded after extensive study that after-the-fact maintenance is not a responsible way to address the actual and potential problems created by coal dust emissions. In particular, after-the-fact maintenance does not, in BNSF's view, provide sufficient protection against the risk of service disruption. Sound regulatory policy teaches that when it is feasible to eliminate a serious risk through measures that are not unduly costly, preventative measures should be taken. Contingency planning to address potentially devastating occurrences, such as the recent Gulf oil spill, should not be ignored simply because the risk of occurrence is perceived to be low. The risk of a serious coal supply chain disruption may seem low because we haven't had one for 5 years. But we all know that disruptions in the coal supply chain are not beyond the realm of possibility because we lived through one such disruption. And the board noted that and established its RETAC in part as a response to that. The precautionary principle spelled out by Professors Kalt and Mitchell in BNSF's rebuttal evidence represents a formalization of the common sense adage, better safe than sorry. BNSF's efforts to foreclose the possibility of an unacceptable event resulting from coal dust contamination is prudent and affordable. As explained by Professors Kalt and Mitchell, under the precautionary principle, the only relevant question about costs is whether the costs associated with the preventative measures are unduly high. I apologize for the feedback here. I'm not sure what's causing it.
I think I coughed, excuse me.
The evidence in this case shows that costs clearly are not unduly high. One option for containment that's been discussed is surfactant application, and for illustrative purposes in our evidence we took a look at the potential impact of surfactant application on costs. In fact, it would have a negligible impact on the delivered price of coal, and in fact, the impact of surfactant application is regularly dwarfed by the impact of changing coal prices at the mines. Even if surfactant application costs somewhat more than enhanced maintenance, which is not what the record shows here, the incremental cost of surfactant application would be an even lower percentage of delivered cost. Any attempt to perform cost-benefit analysis would be misleading in this case. Professors Kalt and Mitchell explained that a comparison of the costs of two alternatives only makes sense where the two alternatives are equally effective. And Mr. Smith, I believe, suggested to you that in his view, the alternatives of containment and after-the-fact maintenance may be equally effective. But in fact, the record here demonstrates that that is not the case. After-the-fact maintenance can't eliminate the risk of ballast destabilization and track failure caused by undetected coal dust fouling. Prevention of coal dust fouling requires that you keep the coal in the car. So in this case, where a comparison of equally effective alternatives really isn't available because they're not equally effective, the precautionary principle teaches that keeping the coal dust in the car is the appropriate course to pursue and sound regulatory policy. Turning to the reasonableness of BNSF's coal dust standards, there are two guiding legal principles. First, Railroads have the authority to adopt operating rules to promote safe and efficient transportation. In reviewing an operating rule, the board's role is not to second-guess the railroad's determination, but rather to satisfy itself that there is a valid basis for the operating rule. Second, shippers are responsible for securing their freight in rail cars so that the freight does not escape from the cars and damage railroad property. Measured against these standards, BNSF's dust monitoring and load profiling rules are reasonable means to achieve the goal of significantly reduced coal dust emissions. Now, most of the comments about BNSF's coal dust emissions standards addressed BNSF's methods for monitoring coal dust emissions. And it was BNSF's adoption of a performance-based standard set out in the tariff rule rather than an activity-based standard, that is, a mandated method for reducing coal dust emissions, that led to the adoption of coal dust monitoring. Mr. Weicker will explain that BNSF adopted a performance standard to give coal shippers the flexibility to adopt dust curtailment measures of their own choosing. The adoption of a performance standard makes it necessary for BNSF to implement a monitoring plan to make sure that coal dust is being kept in the cars. There is nothing particularly novel or complicated about the monitoring system that BNSF has set up. In fact, BNSF's monitoring system is based on trackside monitors and coal dust sensors, and it's similar to dust monitoring systems established in Australia and also the state of Virginia. BNSF's dust monitors measure the level of dust emitted by passing trains. Coal dusting is episodic, and not all trains that dust on their journey will dust as they pass the trackside monitor. But the monitor functions almost like a traffic cop, and the goal is to encourage the adoption of dust suppression measures that will be effective throughout the route of movement. The IDV2 standard, which Vice Chairman Mulvey indicated an interest in at the outset here, is a measure of the relative dusting in the air as the train passes the trackside monitor. And I will describe in light of Vice Chairman Mulvey's question very, very briefly the derivation of the standard. The monitoring system that BNSF has employs dust sensors that collect particles of dust that enter a chamber where they're subjected to a photographic process that translates to an electronic signal. That electronic signal is relayed directly to the computers of BNSF's consultant, Simpson Weather Associates, in Charlottesville, Virginia, and it's the intensity of the electronic signal that forms the underpinning of the IDV2 standard. The standard was derived by collecting 2 years' worth of dust data through these monitors and toting up the total dust units captured by the monitors over that period. We then calculated a standard which, applied to individual trains, would determine how much the dust could be reduced if it did not exceed a particular level of dusting as measured by IDV2. And BNSF has determined that compliance with the IDV2 standard will reduce coal dust emissions by about 85%. And by the way, the 2 in IDV2 refers to the fact that it's a revised standard, the second version, which takes account of dust emitted by lead and trailing locomotives as the train passed the dust sensor. In other words, we eliminate those in the IDV2 calculation. The shippers raise a number of issues with respect to BNSF's use of the electronic dust monitors, which are referred to as e-samplers, but the manufacturer of that equipment has specifically approved the way BNSF is using the dust monitors. BNSF is using the best equipment currently available to monitor coal dust. None of the parties to this proceeding has suggested that a superior alternative exists. If an improved monitoring device is developed, BNSF will be receptive to adopting it. But there's no reason to delay implementation of monitoring with the technology that's currently available. There's plenty of evidence that BNSF's coal dust emission standards can be met through a combination of load profiling and surfactant application. Coal dust can be reduced by loading coal to a more aerodynamic profile, as illustrated in this slide on the right-hand side. BNSF estimates that coal dust can be reduced by about 15% through proper load profiling, and in fact that process is currently in place in the Powder River Basin, although we have learned that simply using the profiling chute that has been designed for this process is not sufficient. The people operating the equipment have to be trained and have to do the job carefully to make sure the benefits of load profiling are realized. Although shippers are free to choose how they will restrain coal dust emissions, surfactant application has proven to be a viable approach, as it is a method that's already used in Canada and Virginia to reduce coal dust emissions. Queensland Railroad in Australia is preparing to implement an extensive surfactant regime in the near future. Surfactants work by forming a crust over the loaded coal that keeps the coal dust in the car during transit. The video clip here shows surfactants being applied to a Powder River Basin train. The still picture in this slide shows the Chinese surfactant application process. And as we noted in Mr. Bob's rebuttal statement, he was informed by the Chinese that they had adopted surfactant application not as an environmental measure, which, as you may know, they're not particularly noted for, but actually as a means of saving money by keeping coal dust in the car. And there is a value to the shippers there. Thank you.
Thank you, Chairman Elliott, Vice Chairman Mobley, and Commissioner Nottingham for the opportunity to address this issue and air this thing out. We know this is somewhat novel and unusual, but very important to a vital part of our economy. After studying this coal dust problem for several years, BNSF concluded that the best approach to curtailing coal dust was to establish a performance-based standard that established a specific limit on coal dust emissions from loaded trains, and left the decision to each chipper and its mine agent how best to meet that standard. As was alluded to today, the relationships between the parties here are a bit complex. We have no direct contracts for shipment of coal with mines, as you've probably heard. We have tariffs and contracts with shippers who are usually utilities, and the utilities, to our knowledge, have arrangements with the mines for the loading and so forth. Those parties own the coal. We do not own the coal. They transfer ownership somewhere in the shipment. The vast majority of things that move today are in shipper-owned equipment. We do own some equipment, but the vast majority is theirs. And we concluded that these decisions, what action should be taken, would be best sorted out by those parties. They have the coal, they have the boilers, they have the mines, on best to do it. Embedded in this process, we haven't talked much about it, but there is an element of an activity-based standard. That's the profiling, the chute monitoring, which has been widely adopted and widely accepted and doesn't seem to be in controversy. We are not aware of any shipper in this proceeding that suggested they would have preferred we made an activity-based standard as a general rule, such as putting on a topper. And I want to address one thing that was alluded to. We can come back to it. In terms of cooperative effort, we had 10, 12 forums over 2 or 3 years. Lots of shippers participated. Lots of mine people came. Ultimately, it's our responsibility to address this. We have the railroad, and we're in charge of the joint line with that other railroad that operates it on it as well. But under a long-established agreement that we'll come back to, we're the responsible party for this as the railroad. So we went forward to set a standard to let the mines and the utilities work out the best way to adapt to it. We think it's the best way to go because we're not in a position to choose the type of chemical surfactant to use for a particular coal. We've obviously done a great deal of testing and shared this information. And we think there's an incentive here for those parties to work out the most efficient and best way to do it. After the May 2005 derailments, many shippers raised concerns about the reliability of coal transportation in the Powder River Basin. They realized it was of critical importance to make this a reliable and efficient source of coal with an efficient and reliable transportation network. They even convinced the Federal Energy Regulatory Commission, which obviously, to our knowledge, does not have jurisdiction over coal transportation. You do. To convene a hearing to consider reliability issues. BNSF and many other parties testified at that hearing. The somewhat laid-back attitude of some of the shippers to this problem today in this evidence is a great contrast to the crisis atmosphere that existed during that period. The STB was involved in addressing this crisis by establishing a Rail Energy Transportation Advisory Committee, where the board specifically acknowledged that it views the reliability of the nation's energy supply as crucial to this nation's economic and national security. That's a quote from your order setting that up. We participate in that effort to this day, as do many parties. Shippers now seem to ask, the shippers opposing, and we're working with many shippers who are not parties to this, that you ignore these reliability issues. We think that would not be responsible to accept a short-sighted desire to minimize costs to control coal dust emissions. Something must be done now to keep the cars in the to keep the coal in the cars loaded like every other commodity. We decided to establish our coal dust standards as a rule. Did I finish the overview remarks? That would be generally applicable to our shippers, remembering that we are talking about common carrier shippers here. The vast bulk of our coal moves through contracts, which are not part of this proceeding, which may or may not incorporate as we work with those shippers. Shall I continue, or do you want me to? We'd be happy to respond to questions.
You have 10 more minutes on rebuttal, and then we will actually go to Union Pacific now, and then we'll have questions after.
That's fine. Thank you, Mr. Chairman.
Good morning, Chairman Elliott, Vice Chairman Mulvey, and Commissioner Nottingham. It's an honor to appear before you this morning to discuss coal dust rules. I'm Louise Ann Wren, Associate General Counsel for Union Pacific Railroad. And I am accompanied by Joe Rabine, who's also represented Union Pacific, who's in the audience. The board now has the benefit of a very extensive record with vigorous and divergent comments. In accordance with your notice, UP wishes to focus on 3 points in my comments. First, preventing deposits of coal dust on the joint line and UP's coal corridor is the best way to assure reliable, safe, and efficient transportation. Second, coal customers play a critical role in prevention because railroads cannot directly prevent coal dust deposits. And finally, mutually beneficial collaboration to achieve prevention will be advanced only if railroads are allowed to adopt reasonable coal prevention rules. Accordingly, in the interest of facilitating discussion between UP and its customers on how to deal with coal dust, we urge you to reject requests that you find the BNSF rules unreasonable or otherwise unduly restrict their application. Turning to my first point, that coal dust prevention is the best strategy for reliable and safe service. We have consensus on at least 2 points, I think, on the record. And that is that coal dust is a dangerous fouling agent in ballast, And the second is that ballast integrity is essential to reliable and safe rail transportation, particularly on high-density corridors. The difference is between those parties who claim that it is sufficient for railroads to just keep cleaning it up and those who conclude that preventing coal dust from escaping cars in the first place is the only sustainable way to ensure reliable and safe transportation. UP is convinced that prevention is superior. I begin by asking that you keep in mind that those who ship no coal still have a real stake in the outcome of this proceeding. Coal dust removal, could you pass the clicker? Or if you could advance to the next slide, please, for me. Coal dust removal disrupts service to shippers who do not ship coal and who do take responsibility for loading their freight, so it stays within the cars or containers. The diagram illustrates the UP coal corridor from the end of the joint line through Nebraska and into Kansas. The yellow boxes show the train count by train type in 2007, before the recession dropped our volume. And you can see that once you get to O'Fallon's and go east, that our coal customers, yes, a very high-density flow, share a corridor, a high-density corridor that had a lot of traffic that is not coal. For example, North Platte to Gibbon in 2007 averaged 140 trains a day, which is roughly one every 10 minutes. And almost half of those, 65, did not transport coal. They transported grain, auto parts, intermodal, beer, lettuce, and those customers share the track with the track that the coal customers are moving over. They should not have their shipments delayed and their cars slowed down because they have to wait for us to clean up after coal customers. In addition, coal dust presents a risk of right-of-way fires, and it's not welcomed by landowners whose property is beyond the right-of-way. Certainly not the organic gardener who's adjacent to BNSF. Their interests are best served if coal remains in the cars and is not left behind to be cleaned up later. But they aren't the only ones who benefit from prevention. Coal shippers also will benefit because if the coal remains in the cars, they get all of the coal that they paid for to burn at destination. And substantial and wide-ranging ballast, bridge, and switch maintenance curfews and slow orders to remove coal dust are eliminated, as well as the associated delay to their trains. Now, the opponents of the BNSF rules say that there's more coal dust to be maintaining because the volume of PRB coal has grown, and they imply that this is an unavoidable and a simple linear relationship. I beg to differ. They overlook that the sheer volume of PRB coal has multiplied the need for coal dust removal, and that volume also increases the cost of disruption. And Chairman Elliott, I think that this may partly answer a question you had raised earlier. Why did this suddenly become a manifest problem in 2005 when UP at least has been transporting coal out of the Powder River Basin since 1984? If we could go to the next slide, please. More coal trains required more track. On the slide, the red lines show where single track became double track became triple track, and even quadruple track in order to meet the demand. As the number of tracks increased in response to an increase in the volume, the amount of coal dust that would be caught instead of blowing off into the high plains also increased, and the amount of track to be maintained also increased. And as more trains were running on parallel tracks, that increased the number of passing trains. It is clear that passing train episodes are high dusting events. So that means that when you had a train that was going down a single main line and it would pass a standing train on a siding, it would only emit the normal amount of dust, if any, at that particular location. But when you have two trains passing each other, that creates enough turbulence that more coal dust is in fact being emitted. So I suggest to you that this is not a linear relationship. Whether it is geometric, I don't know if it can be proved, but I do not believe it is a linear relationship. And one other factor, departing from my prepared remarks, we also found in 2005 that this was at the end of a prolonged and very severe drought, the worst drought in that part of Wyoming in more than 100 years. And subsequent research by Dr. Tutumler has indicated that coal dust is particularly prone that if it's been dry and you suddenly inundate it with water, that its physical characteristics make it go from solid to plastic to liquid in a very dramatic fashion. And we did have a major blizzard at the end of April of 2005 that was sufficient to shut down the highways so that the coal mines were closed, followed by rain, followed by, in the week before the two derailments, which were on a Saturday and a Sunday, there was a blizzard followed by rain, and that weekend is when the joint line literally started falling apart. Not only is there, I suggest, a more than linear relationship with volume and coal dust, but there's greater disruption with more volume. More coal trains means more recrews, greater locomotive idle time, and longer cycle times for cars because trains are delayed by the coal dust maintenance. Adding track maintenance increases the coal dust problem. It does not solve the problem. Only prevention reduces the coal dust problem. So in summary, prevention preserves service to all and presents less risk of property damage and personal injury as a result of derailments. My second point is that coal shippers play a critical role in preventing coal dust. Coal shippers own the coal. Coal shippers own the cars that the coal is loaded into. The mines own the infrastructure that loads the coal. And in addition, they are equipped when coal shippers request them to, as some currently do, to add a suppressant to control coal dust at destination. Or they will add a de-icing agent in order to prevent coal from freezing in cold weather. Or certain customers have them add soda ash to deal with the sulfuric acid problem. So they are in fact equipped to do treatment after the loading of the coal. In contrast, the railroads lack the legal status to apply a foreign substance or equipment like a car cover to the shipper's property. The railroads also lack the legal status to construct and operate a spray or a compression device on the mine's property. We can't just unilaterally go in there and do something about it. We would need permission and authority. The clearest proof that any prevention method is beyond the direct control of the railroad is that all of the tests have required the willing participation of coal shippers and one or more of the mines. And my last point is that mutually beneficial collaboration to achieve prevention will be advanced only if railroads are allowed to adopt reasonable coal dust prevention rules. While prevention is the best strategy for dealing with the amount of coal dust associated with the SPRB coal, and coal shippers are best situated to implement prevention, this proceeding provides ample proof that left to their own preferences, the shippers will not change their behavior. This is not a moral criticism, it's a recognition of inertia. Allowing the coal dust prevention tariff rules to become effective will facilitate constructive discussions between the railroads and their respective customers on how to deal with the dust. As Dennis Duffy likes to say, you want to find the problem before it finds you, and we want to find a solution that works for both us and our customers. Such discussions offer real opportunities for the collaborative development of alternative prevention methods, such as compression or car covers. It is notable that the BNSF rule are proposed do not require a particular method because they in fact do provide for that opportunity to explore and try to develop the most cost-effective and lower-cost opportunities. But if the board were to decide that BNSF may not establish these rules regarding coal dust dispersion, that would freeze shipper and producer cooperation in the research and development of alternatives. For example, we are planning a test to begin in September for a mechanical compression device. That requires the participation of the mine and at least 2 coal shippers in addition to BNSF, UP, and the vendors. All of the participants are contributing cash or in-kind resources or both, and we, of course, will be sharing the data with each other. But if there is no possibility that future shipments of coal must comply with the coal dust prevention rule, then what incentive does a shipper or a mine have to participate with us? And what ability do we have to try to develop the most effective prevention method by ourselves? That is why ICTA recognizes that railroads must be able to establish tariff rules regarding the terms and conditions for the transportation they provide. Rail transportation is a chain of shippers, receivers, ports and terminals, and connecting railroads to move freight from an origin to a destination. Each link depends on the others to do so safely, efficiently, and reliably. Only the rail carrier, however, has a common carrier responsibility for that chain. In addition, we have common carrier responsibilities and contractual responsibilities for other chains that frequently share some of the very same resources. Therefore, the rail carrier is in the best position to encourage behaviors that optimize the rail network and safety and discourage behaviors that disrupt service or are otherwise inefficient or unsafe. So the railroad must be allowed to set reasonable terms under 10702. I submit that the board should allow the BNSF tariff rules to become effective because they have not been shown to be unreasonable and because we think that they will clearly promote safe and reliable transportation. Thank you for your attention.
Thank you for your testimony. I just a couple quick questions regarding the, I guess, the interplay between UP and BNSF on this line. And this is directed to Union Pacific. If hypothetically that we find this tariff to be reasonable, would Union Pacific also have an identical tariff at that point? Would they follow the same guidelines as BNSF with respect to the suppression of coal from these open cars?
No, for two reasons. First of all, the BNSF has promulgated an operating rule which applies to Union Pacific, which is materially the same as the joint line tariff item. So we have already encouraged our customers to comply with the BNSF rule, but we have not adopted the same rule. We have also undertaken to begin to compile the same research on our own lines, because one of the things we have learned from the BNSF work is that if you were to adopt an IDV standard, that it needs to be a location specific. For example, the IDV standard that they have on the joint line is 300, whereas the IDV standard that they have on their Black Hills subdivision, I think, is 154. So we are in the beginning stages of beginning to develop the data by putting a TSM on the South Morrill, and we would have to develop the data. But beyond that, we are frankly waiting to see what this board is going to say, and that will influence our behavior. And we're also thinking that this gets into pricing issues, which I tend to not share. In fact, I do not share with the other railroad about how we would approach our customers in terms of encouraging them to engage in the behavior that we want them to do.
And then just as a follow-up, what percentage of the traffic on the joint line does UP carry of the coal traffic?
Currently, I think it is a 48-52 split, but we have a higher share of the cost of the joint line. Our share is 60% because all of our trains come in from the south and leave from the south, and the costs are split on a car mile basis.
That would bring me to BNSF. If Union Pacific isn't exactly on board with the tariff that's been proposed here, wouldn't that almost make it at that point inherently unreasonable if UP is running across with 48% of their trains without the surfactants going? Wouldn't the coal dust be blowing off their trains at that point? And until there's some kind of joint decision between the railroads, wouldn't there be a problem here with the coal dust blowing off the UP trains if it wasn't in place simultaneously with BNSF?
A rule that we, if I may address this, we had a slide on the operating rule that we have in place. The relationship between Union Pacific and BNSF is governed by a joint operating agreement approved by the predecessor. It has its own system of remedies, including were there to be an issue, arbitration or enforcement or whatever, were it to come to that. There's more of a problem of if we don't get going having a smaller number of, shall we say, free riders because no one, or excuse me, a larger number of free riders because no one starts because there's no rule. The operating rule with Union Pacific, which we anticipate will over time, this is an incremental process, also be effective. We don't know if that'll be faster or slower than with our own customers. The majority of our customers, or well over the majority, are not subject to this tariff rule other than by incorporation through our contracts. And I will also not go into the details of those contracts, but as you know, the vast, well over 60-70% of, no, excuse me, over 75, I don't want to get too precise here, but you've seen before you some of the common carrier moves we have, they are the far minority. They're less than 20%. This is being implemented through our contracts and will be in effect. How Union Pacific does it with its customers is not our concern. Obviously, we're talking about some of the same mines and some of the same big utilities and customers. The lead customer in this complaint is not really a BNSF customer. And we are having some dealings with them, which is to say, no, we believe it's just as likely if this rule goes into effect and far more likely, and really the only way it gets into effect over time in an iterative process through our various customers.
And if I could clarify, please, Chairman Elliott, I am not saying that UP is going to tell our customers you can blow it off and ignore the BNSF rules.
Okay.
How we approach our customers to encourage them to, in fact, comply with that rule is a matter that we are going to be working out in customer-to-customer interactions. And it, to a certain extent, we can't, one, we aren't going to reveal that in front of our competitor, and secondly, it's hard for us to formulate exactly how we might do that until we know the results of this proceeding.
Okay.
But we are shoulder by shoulder with the BNSF in believing that prevention is, in fact, in the best interest for all stakeholders on the joint line.
May we put up the operating rule, Chairman? It's a one slide.
That's fine.
This is not an attempt to take more time from the parts we didn't cover, but
You're not on the clock now. You're okay.
This is published pursuant to the STB ICC approved joint operating agreement. You'll notice the first words, as soon as practicable. We know this is a haul here to get this thing done, although it could move very quickly within the next year or two, but it is not automatic, and the as soon as practicable is an explicit acknowledgement of the complex relationships we're all facing here. It is our responsibility, we believe, that is BNSF Railway, as the lead operator, dispatcher, maintainer of this vital facility, to, shall we say, manage this process, but our vehicle with the other carrier is an operating rule with its own separate enforcement mechanisms.
Actually, that's very helpful. Thank you. And just one other question I had with respect to the compliance, and this is the BNSF. As I see the compliance method, you have these machines that monitor what type of coal dust comes off the trains, and that you use a traffic cop analogy, and that some trains will blow off the dust and go over the number, and some may not. Wouldn't it be, I guess, using the term of the statute, more reasonable if you had an activity-based safe harbor where, say, the coal shippers would put the surfactant on it, and that in itself was sufficient enough to pass the tariff, as opposed to this monitoring system that may not be entirely consistent.
I would argue that it is not necessarily more reasonable. Some parties may say it's less reasonable because we were compelling activity. However, having said that, we are perfectly willing to do that. We are quite open, and I will just say, without getting into particular things, you can imagine us having a discussion like this with a contract customer. If the chairman is suggesting something along the lines of should there be or could there be or would we publish or amend to say there would be a presumption that if you used one of the approved surfactants you were in compliance, certainly. We're not close to that. For a given period of time, this is going to be an evolving process, 2 or 3 years. You did it right and it worked, certainly. I would flip it around a little bit. It would be just as reasonable to say all the coal should be in the car. Forget about this measuring thing if it's too complicated. But in terms of what you were saying, would an activity be a reasonable substitute? Not taking away. We don't think we should take away that option for the shipper to find another way, whether they want to explore compaction or covers or something else. Certainly.
Sure.
I guess the only thing I would add to that, over the last 5 years, we've been in active dialogue with our shippers through a variety of forums, and at the end of the day, they told us they wanted a choice. They wanted a choice in terms of how to comply, and that's why we thought the performance-based standard was a reasonable start.
And my thought would be that there wouldn't be, you could have an activity-based safe harbor, but also still have the measuring to encourage possible, economic discovery of what is most efficient. So that is good to hear that you would be open to that. Vice Chairman Mulvey.
Thank you. Thank you, Chairman Mulvey. The accidents that occurred in the PRB were 5 years ago now, and I assume that quite a bit of coal dust has escaped from cars over the last 5 years, and even with the maintenance, so coal dust builds up, etc. I'm sure that the weather in Wyoming has been cold since then, and we've had again rainfall. And the shippers have argued that the problem of the derailments in the Powder River Basin were due largely to construction problems, maintenance problems, inadequate maintenance problems, some ties that were not as good as as they could have been, also to black drains, and also fairly unusual weather pattern that developed. But there hasn't been an accident since. Doesn't that speak to the issue that perhaps it was not coal dust that caused these accidents, but rather somewhat unique problems with both construction maintenance before that and weather?
Yeah, well, clearly no derailments is a good thing, and our overall network service interruptions due to derailments are down across all categories. The two derailments, the back-to-back derailments in May, we believe were caused by a confluence of events. That included coal dust, absolutely, positively included coal dust, as well as significant precipitation and the spring frost coming out of the ground at the same time. We have increased our maintenance since then. We've doubled our undercutting. And we think that's appropriate. All that said, there's still coal dust in the ballast section on the joint line. And at the end of the day, as long as that coal dust is in the ballast section, there's still a risk of a service interruption with the right confluence of events. We're going to work hard to prevent that, but that real risk of a service interruption and a disruption to the supply chain is present today.
But it is true that up to now, there has not been another derailment due to the fouling of the ballots because of coal dust, because of your maintenance activities in part anyway.
That is true.
You mentioned about, and you showed the picture of that organic farm, and I always when I buy organic vegetables, I had different assumptions about what that meant. But Yeah, that's a little disturbing because we talk about the shippers, the coal mines, we talk about the railroads, the carriers who are all affected by this, but clearly there's also impacts on farmers with operations along the rights of way, and there's quite a bit of that, I would think. And also animals that could be exposed to some of this as well. So then we know that coal dust is probably toxic if it's ingested or inhaled or what have you, certainly not healthy. Has the EPA ever gotten involved in this issue? Have they weighed in saying that, this is an environmental problem and that there ought to be something done to limit the amount of coal dust in the atmosphere?
The Wyoming DEQ has expressed interest in this issue in a general matter. The EPA, to our knowledge, regulates actually dust at the mine in the loading process and or at the utility. But the answer to your question directly is no, insofar as our transportation. We are very much aware of the larger societal and I would call them externalities involved in this. This is an operating rule dealing with the railroad. We think and have discussed with our customers and the mines that this would be a very, very rational thing for the private sector to work towards compliance of dealing with a problem that could have much broader impact beyond our narrow right-of-way and their mine. And we think that's the right way to go. Having said that, this is a rule directed at dealing with these coal cars on our railroad, but we're not mindful of a broader Big E out there. And I'm sorry, Tim, did you want to?
I was just going to mention that I believe our opening evidence references recently adopted EPA rules related to stationary coal sources. Mm-hmm. So far, and this I think is the thrust of Mr. Weiker's comment, we don't know what's coming down the road. So far they haven't been looking at mobile sources of coal dust, but that one could imagine that might be a concern down the road.
Thank you. It was referenced before that this represents some sort of external diseconomy, negative externality. A characteristic of negative externalities is that they don't have a ready market, and that market solutions tend not to work for externalities, and that is why the government gets involved when there are negative externalities or external diseconomies. Well, that would suggest, of course, that perhaps there is a role for the EPA, whether it be the federal or whether it be the Wyoming Department of Environmental Quality.
If I may, Vice Chairman, we are not suggesting that ourselves, but I would say you're quite right in terms of the externalities. This issue, this sort of circular issue, just maintain the right-of-way more, do more maintenance. It's obvious that there is nothing that can do about that farmer or the animals or the general ambience beyond us.
There's also data that's been gathered by BNSF that indicates that while coal is a major constituent of ballast contamination, other contaminants are also present, including dirt, other debris, etc. And here we are out in Wyoming, where the weather is hot and dry in the summer. There are strong winds, and of course, a lot of these dirt and other debris can get into the ballast as well. If you would put this tariff in place, it wouldn't take care of the problems that's caused by other contaminants, and you would still have the need to clean the ballast periodically, etc. So does this really replace, or does it really reduce very much the need to do the ballast? Or I know you said it's about twice as common, but I think the weather out there is also unusual, as well as the fact that there's coal dust.
Our testimony clearly outlines a significant amount of science that we put up against determining that coal dust is the number one foulant of the ballast section on the joint line. I think that's well documented in our testimony. As I said earlier, for a 400 million gross ton railroad, the joint line again is the heaviest railroad in the nation. 400 million gross tons travel across that railroad every year. That requires a 10 to 15 year undercutting cycle to remove ballast, broken down ballast, dirt that gets in from blowing events, those kind of things. now we're on at least twice that cycle. We've got one location on the joint line, Naco Bridge, which is at a key junction into one of the mines. We cleaned coal dust there a year and a half ago, taking out the entire 24 inches of ballast off that bridge, and we're going to be back there again in less than 2 years to do it again. So the amount of coal dust is at times staggering.
Well, one other question for this round, and that is, I know you've employed consultants to look at this, and engineering firms, et cetera, and so has the other side, and I don't mean to disparage the work of these consultants. I think a lot of us have done consulting at one time or another. It is also true, however, I find very few consultants who say, well, while this party paid for me, I'm afraid my results do not agree with their position. And so typically consultant reports tend to verify what the party paying for them wishes to hear, or they don't get presented. There wasn't any attempt at, has any what I would call an unbiased group, whether university researchers or whether it be the National Academy of Sciences Transportation Research Board, has any what I would call objective, unpaid for groups looked into this problem of the coal dust and made any findings, or have there been any meta-analysis? Meta-analysis is one that, where you gather a whole bunch of disparate analyses and see if you can find current trends and what the overall truth might be.
If I may try this one, Vice Chairman Mulvey, I think there is a distinction between some of the consultants in this proceeding, which is we are relying very substantially for purposes of this proceeding, which is in the nature of litigation, upon people whom BNSF retained in the real world to try to solve a real world problem. In fact, the person from Simpson Weather Associates, Mr. David Emmett, was retained by BNSF because we understood that he was the foremost coal dust expert available. He had worked with NS on dealing with their problems in Virginia. So he got in this thing not to support a position, but to help us find an answer to a problem. Now, given that he thought he found an answer or an approach to the problem, it's not very surprising that he would come into this contested proceeding and support the results that he achieved when he was under contract to solve the problem. So I think there's a distinction. To my knowledge, there has not been the sort of fully independent academic enterprise, although the professor from the University of Illinois, Dr. Tutumler, BNSF did fund some of his work, but I believe he views himself as an impartial academic who was studying this coal dust issue for academic reasons. And I'd say he's sort of in the same camp as Dr. Emmett. That is, he did the work to try to come up with some answers to what seemed to be a problem, and now in the context of this contested proceeding, he's not backing away from the conclusions that he previously found.
And if I could volunteer, in our opening evidence, we put in the testimony of an engineer by the name of Molesky. He works for a nonprofit organization. They have done a great deal of work involving coal dust and other airborne emissions, including for the Powder River Basin mines, including studies for the government. And it was a very different process working with them than most of the consultants we had to work with, because it was peer review in his organization and had to be approved. And if you'll notice, it's not in a typical format. So this is not your typical litigating consultant. And basically the gist of his testimony was that he thought that the mechanisms and the process BNSF was using for its IDV standard made sense to him.
Well, that's good to hear. And I do recall reading the testimony you submitted referring to him, and I was following up on that, and I was just asking the question as to whether or not there are other peer-reviewed, very often research that's even when it's done for private, there's also work that also gets published university professors interested in tenure try to get their things published in the reputable journals that are peer-reviewed. And there's one case where it's been peer-reviewed, at least by the organization he works for. And if there's a list of any journal articles that you are aware of, whether it be in the environmental literature, the economics literature, the transportation literature, what have you, that addresses this issue and comes up with findings, and I address this also to the shippers on the other side, that there are these evidences out there that we ought to be aware of, it would be very, very helpful to the board.
We'll certainly pursue that, and as I say, these experts that develop these standards, we were going down this path 2 or 3 years ago, 2 or 3 years before we had any idea that there would be this proceeding, and we'll continue to keep the board advised.
Thank you for the moment.
Commissioner?
Testing?
Just shout.
You want to?
It's working early. The light's not going on.
I want to sit here for a few questions.
Maybe just angle it. Maybe the staff could just take a quick look at this. Maybe it's quick to it. It worked earlier.
Just move over here. Come on, Chip.
Thanks. Let's angled over here. Thank you. Can you try pushing that button, see if you can get it to work? Thanks.
As you can see, this is not a particularly technically oriented group.
Sorry about that. My light wasn't going on. It worked earlier, but these we're still working with the sound system. I did want to mention just to the witnesses, it may help sometimes if you're not, although maybe I should not say this now, because what I did was I deactivated mine by pushing the button so I wouldn't distract my colleagues or you if I were to ruffle papers, and I was going to suggest that everyone adopt that, but maybe I shouldn't because look what it resulted in. A couple questions. Mr. Fox, thank you. Your testimony was very interesting, a lot of interesting numbers. Did I hear you correctly that you said that approximately 500 pounds of coal dust are lost per car on average based on your experience and your observations or your staff's observations?
Our field studies have shown that the range is 250 to 700 pounds lost from the top of the car, and obviously we took the mid of that range with a 500 estimate.
And then you further stated that approximately 2,000 tons of coal are lost each day if you look at the traffic volume.
And the math there was clearly 70 loaded coal trains a day between BNSF and UP. We assume an average of 120 cars a train. You do that math out at the 500 pounds, and up to 2,000 tons of coal are lost on the joint line and other rail lines every day.
And we saw some statement in the I forget which panelists mentioned this, that $30 a ton is some sort of a typical or not unusual rate for delivered ton of coal. Did I see that correctly? I know that can vary.
That was delivered cost, freight plus the cost of the coal.
Okay. And then, Ms. Wren, thank you. You helped us by reminding us that one of the concerns here is to make sure that shippers get all the coal that they paid for. If I can paraphrase what you said.
Yes.
It seems to me we've got a lot of, and also you helped us understand that the coal is, of course, paid by the shipper based on its the volume and weight at the beginning of the journey at the mine. So basically, we now know, and I guess people have known for a long time, that shippers are not getting a significant amount of the coal that they paid for. Have the railroads, or either of the two railroads here before us today, taken measures to reach out and communicate with the customers to try to offer rebates or refunds or credits or some other, if you factor, it's a 365-day-a-year operation based on my understanding of the Powder River Basin, 2,000 tons lost a day, that starts to add up to be real money. Can the railroads speak to that question?
I don't necessarily want to refer to any particular detailed discussions, but clearly the issue of, from our standpoint, the value of the coal being lost should be an incentive on its own to the customer. There's a little bit of a dynamic here. There have been issues of whether who's really harmed more, us from our parochial standpoint by the impact on our railroad, or the nuisance this causes to us. We do not view ourselves as being responsible for the loss of the coal. We think that is the customer's responsibility, and we would think that would be their own incentive to address it.
Now, Mr. Weicker, though, I did take note that you did say that ultimately it is the railroads, and you said it was so I wrote the railroad's responsibility to address this situation. So how do you reconcile that statement with your statement a minute ago that the railroad is not responsible for commodities that are lost during rail transportation?
I think I should differentiate. BNSF is the primary operator of the jointly owned line, is the party responsible for the actual implementation of maintenance, for the dispatching, and for having appropriate rules to defend the integrity of that asset, that vital national asset. That makes us responsible if there needs to be a rule which makes it clear that the coal should be in the cars. That does not make putting the coal in the cars our responsibility. We believe that is still at core, just like for every commodity on the railroad, the shipper's responsibility. But we're the one that has to go publish the rule, the operating rule for this asset. This is not, in our mind, a loss and damage situation, or if we have a derailment with a container full of widgets someplace, we are responsible to the owner of that commodity for damage to the widgets. We do not view ourselves as responsible to the shipper for the coal that is being lost because it's blown off of their cars.
Putting aside for the moment the question of how specifically this problem should be solved, do you agree that at the end of the day, if this problem persists, it is ultimately the railroad's responsibility is to ensure that the problem does get solved?
It will be ultimately our responsibility to continue to pursue it to protect the railroad and our transportation for all our customers. There are limitations, which is why we have this rule for a performance-based standard on what we can do. We ultimately cannot be responsible to put surfactants on the coal cars or to have them loaded properly because we don't own the cars, we don't control the mines, we don't own the coal. We have to promulgate the rule. This touches a bit on your enforcement question. What do we do next? And that comes down to if we do not have voluntary compliance, further actions would be subject to the jurisdiction of the board. But we view this as a problem that has to be solved, and we have to go down that path. So in that sense, we have responsibility. We do not have control over many aspects of this. We can't require people to ship. We have contracts, of course, for people who want to ship, and we have tariffs for people who want to ship. So I guess there's sort of I'm not quite sure of your question in terms of what it means by ultimate responsibility. We think this problem has to be addressed, and we're going to continue to move forward to address it insofar as the railroad and what we can do, and then publishing rules for the other parties to the transactions.
Perhaps my question was overly complex. What I meant to get at is that every day all over the country, railroads are in the business of inspecting cars and making sure that cars are safe and are compliant with railroad requirements before they head out onto the railroad right-of-way and throughout the system of interstate railways. Rail cars can be pulled, removed, detained, the whole host of different options and remedies. Isn't that basically the railroad industry's, if not best, perhaps last course of action if a negative situation that is posing risks of various sorts that we've heard about today continues to persist, that you have the option to deny service?
Yes. Can I start?
Please.
I mean, given our mutual interest, we do expect that customers will comply with the operating rule, and I think over the last 5 years, we've clearly demonstrated a willingness to work with a variety of stakeholders along those lines. So we talked about, good faith effort here, and at the end of the day, effort will go a long way, I believe, in terms of what our ultimate decision is.
And to answer your question, if I may, in the theoretical, legal, regulatory sense, yes, it is ultimately our responsibility. If we have a piece of equipment that has a faulty bearing that does not comply with national rules for safety, it is our responsibility to look for it, set the car out. If we have an overloaded car of coal or of any commodity, of coiled steel, we have an obligation to look for that, inspect, and do something about it. We have an obligation to comply with a variety of FRA rules for the safety of our employees, for the integrity of equipment. We have to keep track to standards. Those are all our responsibilities. We have not threatened anybody with anything here. Back to your or else question, we recognize, for example, if I may, we have rules that say if a car is overloaded, we can set it out, charge the shipper for the set out, have it offloaded or whatever. Some rules, we have lots of rules for blocking and bracing that don't necessarily, we expect them to be complied with. They don't necessarily say exactly what happens if the car isn't done right. If that situation is occurring, we might publish such a rule. Have we thought about such things here? Of course. Would that be subject to your continuing jurisdiction? Insofar as it didn't come through a contract, but it came through a common carrier publication to come back to you, which is why we think that issue that rolls around in the background is premature. We think the rule itself that says the coal should be in the car is clearly reasonable. Where we do propose some remedy that was questionable, as to common carrier shippers, you clearly have jurisdiction over that and its impact on the customer.
Mr. Weicker, or any of the panels, this seems to me to be, broadly speaking, putting aside the technical nuances of coal dust and its various characteristics and attributes, this is not really a new issue, is it? I mean, in its broadest terms. The AAR has an entire structure of technical committees that are comprised of, my understanding is, of car owners and sometimes shippers and certainly railroads to deal with all kinds of challenges related to rail cars and necessary improvements and technological improvements. And at the end of the day, and we often get visited, I know I'm sure my colleagues do too, about some of the participants on those technical committees who don't work for the railroads don't always feel they have an equal vote when the votes get counted. But that's for a reason, because at the end of the day, as I understand it, the railroads is ultimately responsible for what happens on the railroad and the railroad right-of-way, and you've got to make decisions, but that's an effort to at least get input in an informed way and give people typically some timeline whereby a change or a new standard will be adopted. And this has gone on over hundreds of times over the years, is my understanding. What's the problem here? Why hasn't the system worked related to coal cars? I just don't. I'm having trouble. Help me understand. Every other commodity has had its cars altered, adjusted, improved, standards imposed, and then there's this mysterious coal car situation that somehow has slipped through the cracks, no pun intended. What's going on here?
If I may, this is not about the car design. This is about loading practices. And both the AAR open-top loading rules indicate those are minimum standards. They're not the only standard. They're the minimum standard that has to be complied with. They also incorporate the Uniform Freight Classification rules, I think Rule 27, that basically says, here's the principle. Shippers are responsible for loading the freight so that it can move safely and not cause any property damage. I mean, that's the principle. It then recognizes that carriers, specific carriers, dealing with their particular circumstances, have the ability to adopt a particular rule. And apparently, because let's face it, CSX and NS have been transporting substantial quantities of coal long before UP was a major coal player. They apparently haven't run into this circumstance and haven't felt a need to do it. We were not aware that we had this problem with coal dust until the events of 2005.
Mr. Fox, you helped us understand a little bit more of the details of how your railroad actually goes in and periodically removes the coal dust from your track bed. And what do you do with it when you remove it? Where does it end up going? And it looks like you were putting some of it back on rail cars. Can you help us understand that a little better?
It's a combination of both. Oftentimes we'll load it in rail cars and take it to a disposal site. Other times, frankly, we put it onto the right-of-way roads, well away from the track structure.
And you bring it to disposal sites for a reason? Are those regulated? Are those for unsafe materials? What type of sites are those?
I can't answer that. I know we take them to North Dakota, and I assume it's a facility that can handle that type of commodity.
But you also load, you're actually sort of in an odd way, but out of necessity, it sounds like you're in the business of originating train loads of coal, it sounds like.
Again, in 2008, we had a specific effort around coal on the right-of-way, around stream beds and waterways. That was 300 carloads of coal taken out of those waterways on the joint line, and those were hauled.
So when you originate coal loads, how high do you load the coal up in the rail cars? Here's a great example to understand, maybe a best practice. When you have a chance to control the source and the loading and everything else to do with it, do you stack it above the height of the actual rail car?
I can't answer that.
Would you be? It would help if the chairman, with your permission, could we ask that the record be, if possible, be addressed on that question be addressed? I think it would be important to know whether a railroad that originates train loads of coal actually has a practice of stacking the coal above the height of the rail car. They have another practice that seems to possibly work better to reduce the release of coal.
We'll certainly look into what happened with these cars. This is a somewhat unusual situation for us. We have no mines and we buy no coal, and so we're not in the business. But we will follow up with. And if I could, Commissioner Nottingham, briefly on your prior question about.
Before we leave that completely, I don't want to pretend to be an expert on all the dynamics of rail cars and coal heights, but I'm guessing when your maintenance people, who are professionals, were told that their job is to get rid of this coal and put it in rail cars, that they probably didn't fill the rail cars up above the height of the rail cars themselves with coal. Because if your job's to actually get the coal off the railroad right away and make sure it doesn't blow away, you probably don't load it above the rim of the rail car. But I look forward to the record getting clarified there. 'Cause it does kind of beg the obvious question: why do you load rail cars above with a material that's known to blow away above the rim of the car?
Well, as Lou Ann mentioned earlier, we are going to we have a pilot of some new compaction technology that will start next month on the joint line.
I guess I should rephrase the question. You're not actually loading in a commercial everyday mine practice. I should say, why do you allow your customers to load material? Because I don't think you allow your grain customers to load their grain in a way that routinely blows away, or your merchandise or your flat screen TVs coming into LA Long Beach, or your cases of wine, or the beer we heard about, or
to some extent, this is a product. This situation of the growing coal shipments and the nature of the loading has probably evolved from everyone's attempt to seek efficiency. Obviously, the more coal you can get in a car, the more coal in a certain length of train, the more utility you can get from the expensive equipment the shipper buys. The train crew and the locomotives can haul more coal in the train. There's a balance here. There's no question there was a lot of pressure in recent years to be as efficient as possible. Trains got longer, loads got longer. Having said that, that doesn't eliminate the need for proper loading. And tying in with that prior concept, we have now found ourselves in a unique situation in the Powder River Basin that requires greater scrutiny, tighter rules on how this coal is loaded here, which could be different than what's happened nationally. The coals are different, just came out in some different questions, so it may not be the same for NSCSX or whatever. But here, we see this as a real problem for this source.
Mr. Weicker, is your client, is BNSF your company? Have you adopted is this part of the adoption of a no-spill? I used this phrase earlier for a reason, but sort of a no-spill policy. Are you going to be applying this across the board to all your customers over a reasonably, in a reasonable time period? Because it does, I guess I will say, practices tend to look less reasonable. And that doesn't mean that they're unreasonable, but they tend to look on the scale of extreme unreasonableness to extreme reasonableness. They tend to look less reasonable if they're applied to some shippers and not others who are similarly situated.
We clearly have a policy of pursuing this compliance through the Powder River Basin. We've extended it. We have the north route. We have standards going in there. We are looking at it very closely in New Mexico. If you mean in terms of customers in general, for all commodities, well, it's making us much more acutely aware of, gosh, commodities should stay in the cars, whether it's caustic soda, chlorine, wood chips. Doesn't have to be something hazardous. Plywood, things shouldn't roll off. We're more sensitive to that. But more related to coal shippers, we are looking at it on a broad basis. As some of the slides show, the coal dust problem isn't limited to just this section of railroad. Having said that, what makes this unique and unique for a rule is this particular stretch of railroad with its 24 mines is probably the largest single concentrated source of coal, certainly in the United States, maybe in the world. And therefore, by addressing this problem at its source, we are really coming to grips with something unique that is very focused. But we're looking at across our system on coal.
We have certainly, as situations have come to our attention where the loading practices are not consistent with keeping the freight in the car, we have taken action. For example, we adopted a netting requirement for wood chips. We have previously adopted, I think in the last 5 years, a requirement for soda ash customers to make sure that they're not leaving loose soda ash on the outside of the car, because we found that the soda ash, which is a caustic, was interacting and it was thrown off our signal system. And so we finally said, we can't have this, you need to do it. So when we become aware of a situation that is causing us a problem, we are prepared and have been adopting rules that are necessary. But I think, as Mr. Smith indicated for the Department of Transportation, most customers have an incentive to load the freight to stay in the car because it's their freight. So they already have an economic incentive, and I think that most people are trying to do the same thing. So what we're probably dealing with are the exceptions, not the norms. But there was just a different practice for coal, and for whatever reason, we are learning that the consequences are much more significant than anybody assumed when at least we began moving coal out of the Powder River Basin in 1984.
Mr. Chairman, I'll wind up in a second. One or two more questions if I could. Mr. Fox and maybe Mr. Weicker can help with this as well. You described it in very detailed words, the expenses and the costs and the processes that are required to remove coal dust from the railroad right-of-way. How are those maintenance, and they sound like increased costs. They're not the same costs you have on your southern tier line going, west, east, west through Arizona, for example. They're costs somewhat unique, extra maintenance costs unique to the Powder River Basin. How are those costs recouped and accounted for as you look at your rate structure to all of your customers? Are they uniquely targeted and applied to the rates of electric utilities who ship coal, or should grain farmers who also share some of the same down track, should they be a little bit concerned that they're paying a little more because of this problem?
We think all our customers should be concerned that increased costs, this sets up possibility of increased costs of the whole system and affecting both service reliability and cost for other shippers. Having said that, we don't make cost-based rates. Clearly, costs are a huge part of the regulatory structure, and when we have, upon occasion, had a rate case even on coal before this board, the costs are very, very important to justifying those rates. But that's not where they come from. We do not have direct flow-throughs or cost nexus for the maintenance on particular shipments. Clearly, we look at costs internally when we consider rates, because our goal is to have margin and to have revenue in excess of costs, not speaking now in terms of the SAC and all the board models, because we're a business and what we're in. But there is, to some extent, we almost view it from our standpoint, that this growing problem in the last few years has been shifting additional unanticipated costs on our company through a growing problem coming from the coal dust coming off of the cars. That is not to say that we don't fully recognize that if we've seen this thread in some of the argumentation that if we save money by not having to do excess maintenance, what should happen about that? You have just what happens in our contracts, and when the contract's in effect, that's not an issue for the board, with all due respect. And of course, if it isn't in a contract, they have their remedies, as we well know, to approach the board for the general or specific level or raise for a specific customer.
That's all I have for now.
Thank you very much. Do you have any more?
Yeah, a couple of more questions. Again, I said I've been interested in this IDV2 issue and measure. Why doesn't the railroad release to the shippers the computer code that produces these values so that they can verify it, they can see how it's being calculated? There's also some concern that maybe the IDV2 values don't really correspond very well to the amount of coal dust in the ballast. I mean, you see the stuff blowing off the tops, but it may blow past the ballast and be doing more harm to the countryside than to the ballast per se. So how do we know that there's a correspondence between the amounts coming off the trains as measured by these receptors, which I believe, by the way, are not, the receptors tend to be some number of feet away from the rights-of-way. So again, you would expect to get a heck of a lot more of the coal dust not fouling the ballast, but rather be fouling the environment near the ballast. And I guess the final part of that is, any idea what percentage of the coal dust? You mentioned 500 pounds a day gets blown off the a car, 500 pounds per car rather. How much of that goes into the ballast, and how much of that goes into the general environment? Any way of calculating that?
You want to start with that, and then we'll do the computer stuff?
I've seen no calculations of that percentage.
But the calculation that's being done by the receptors is a receptor that is 60 feet from the right-of-way.
It is
approximately.
It is off the track, yes.
So we don't know whether or not it's measuring what's off the track or what's going down into the ballast. We know that it's not 500 pounds a day per car going into the ballast that's being blown up, but that's dispersed all over the place.
Some of it may be on those farms. We don't
Maybe
know.
on those farms. So
500 pounds was calculated through a different method than the IDV.
Oh, it was.
IDV is a point
Right.
measuring device at one location.
And so that does not measure at all the amount. So okay. So
It does tell you the train dust.
okay.
Did you?
Yeah.
Your question about the computer code, we don't own the code. This is sort of like we don't own Minitab, we don't own Excel. Having said that, data can be available, but there is an issue of we hired someone who had a proprietary system 2 or 3 years before this litigation, and we don't have the right to necessarily give that system to somebody else. It's something we bought.
It's proprietary then.
Yes, it's proprietary.
You showed a slide of China using surfactant, and I assume that's nationwide in all of their mines, perhaps. And but what about what do the Canadians do? We have here the two Western railroads, but the CN, CP, they have. Do they have any processes in place? And also the short line. I know the Eastern railroads also had this problem, but to a lesser extent because of the nature of the dust. But has anybody else taken the tariff route that BN is proposing?
The Canadian Pacific does treat their coal. The Norfolk Southern treats some of their metallurgical coal as well. And there's coal that's being treated in the Powder River Basin as we speak for select customers.
But no one else is taking the tariff route that BN is. Mm-hmm.
Well, I believe there's some form of CP item, but frankly, I don't think we don't necessarily know the commercial relationship between that railroad and that customer. 2/3 of our tonnage is actually moving, or more than 2/3, through contracts that'll be reflecting this by the end of next year. But that won't necessarily show up in the tariff. It will presumably, without getting into details of this, it's going to mirror what we're trying to do here in some respects. And similarly, I don't think we can speak authoritatively to how the other railroads have implemented it, per se. If we had a precedent, specifically in a rule, that had been ruled on somewhere, we'd show it to you.
You also noted that the railroads' rates are not cost-based rates. We don't have cost-based pricing, but we have demand-based pricing. Yet, on the other hand, there are things like the fuel surcharge issue and now this one, which does seem to relate to costs. And some of the shippers feel that the costs that they're paying, the rates that they're paying already account for maintenance, and that these maintenance costs are picked up in their rates. And this would involve sort of double dipping or charging again for the same service. Yes, the cost of maintaining the track is already in the rate. Now there's going to be an additional cost on top of that. And how do you respond to that charge that this could become something of a profit center, as they charged also with the fuel surcharges?
We have a relentless drive in our company to improve productivity, lower costs, improve efficiency. That does not mean that ultimately gets reflected in the nature of the business we're in our market-based rates. It does not mean that there is some sort of automatic pass-through. If you take the flip of what you said, if, for example, hypothetically, we tried to impose some sort of charge to apply a surfactant, there's packed into that question and that hypothetical a couple of things. We can't do that. We don't have the right to. It's not our coal and so forth. But trying to mirror your surcharge question, were we to do that, you'd have jurisdiction over that charge. However it fit into rates or not, you have jurisdiction over the basic rates we publish if someone thinks they're too high. We don't think we owe a customer something for clarifying and confirming a duty to keep the commodity in the car, including if the fact that were to be done were to reduce our costs.
One last question. Some of the shippers have pointed out that spraying surfactant leaves a sticky residue. And since the shippers are the ones who own the cars, they're concerned that sticky residue, et cetera, could ultimately do damage to the cars. We talked about what the railroads are willing to trade off in terms of, safe harbors and all of that. But would the railroads be willing to absorb the cost of repairs on shipper cars that might be caused by the use of surfactants to keep the coal dust down?
We believe that the responsibility to keep the coal in the car is the shippers. One of the reasons we have gone to a performance-based as opposed to an activity-based standard is we are not mandating. We are open to, if a shipper wants to say, does this comply with, presumably we'll go that way, but we don't want either to accept that liability or to have that control over someone else's car and equipment. We believe the tests are showing and have shown and experienced that, and in other countries and other parts of the world, we know that this can be done, and we think it can be done safely. Having said that, it should ultimately, we think, be the shipper's prerogative and to control that process.
Thank you.
Mr. Chairman, one additional question? Thank you, Mr. Chairman. Mr. Weichert, I want to just make sure I understand the sort of proper alignment of responsibility and accountability here. You just said, if I heard you a minute ago, in responding to Vice Chairman Mulvey's question, that the railroad is, if I heard you, is not responsible for this coal dust leakage. Help me, though. I mean, when you accept a rail car onto your system and transport it, you are, at that point, you become responsible for the safe and transport and for getting what the shipper has paid for delivered to the ultimate destination. Are you not?
Yes, we are.
And you have a very strong and I think often reinforced by this board and our predecessor tool to protect you from unreasonable risk in that responsibility sharing, because you have the right to inspect the car and refuse to put it onto your system, correct? If there's a problem with leakage or safety. For example, if a grain car shows up and the door's broken or hanging loose and grain's leaking out, your people are trained to actually take that and put it aside and refuse service, correct?
That's right. If it's not properly handled, yes.
And I won't even go into all the hypotheticals regarding hazmat. I mean, of course, you will refuse, your people would refuse, understandably so, to move a chemical car. if it was leaking. So putting aside, what the right solution is here ultimately, do you agree that once the rail cars are moving along and accepted and placed and accepted by the railroad and moving on the railroad right away, the railroad's responsible for any leakage that occurs?
We are not responsible for the consequences of the leakage if a loading rule hasn't been complied with or if the equipment is defective. The relationship between the railroad and its customer and the loading entity is multi-party and is multifaceted. We're not responsible for for the supply of these equipment for coal in the vast predominance. We have some equipment we supply, but that's the nature of the industry. A car maker makes that car to industry standards, federal FRA standards, often that have been promulgated through the AAR. We have a variety of responsibilities to inspect, to deal with equipment that is improper and take it out. If we are the cause of a derailment, God forbid, then we are responsible in general for the commodity and the damage from that derailment. Our responsibility in this situation includes, as this operator of the joint line, to have the rules in place that we think are appropriate for this unique territory. And if implied in this question is at some point to properly enforce them, certainly. I guess the resistance is that we are not quite, I believe the legal doctrine was res ipsa loquitur, or whatever it is. The fact that we take a car and it's good at the beginning if it's a car of widgets or chemicals or something, doesn't make us universally responsible for the effects of improper equipment or defects in the equipment. There's a multi-party relationship there. I don't want to get into finger pointing. So it's very complex. But I think our role here is we got a problem here, and we're managing this joint line, vital national asset, and we see this problem, and it's time to do something, and it's time to say, the big source here, coal's coming out of the top of these cars. Let's tighten up the rules.
If I understand Commissioner Nottingham's question correctly, I think what we're saying through this rule is we don't want to start down the right-of-way with a coal car that's going to leak. I mean,
well, Mr. Seif, that's a very worthy intention, but with all due respect, your clients and other railroads seem to have been doing this for hundreds of years, so that that aspirational goal that seems to be falling a little short.
We clearly are in a process of continuous improvement, and if we would have to acknowledge this is a problem that has grown and that wasn't recognized in the past, we probably share some of the blame, both for not recognizing at a given time or not acting sooner, more aggressively with our customers. 2005 was a huge wake-up, realizing what had happened in a dry environment and a confluence of events, and we want to move forward to address it.
And the board has recognized in comparable situations the fact that a particular approach has not been pursued in the past doesn't make it unreasonable when you decide that circumstances are such that it's now time to adopt this approach. The North American freight car case the board decided in 2007 specifically stood for that proposition, and others as well. The way the world is today, BNSF has come to a judgment that we no longer want to start down the road with these coal cars that are going to have dust blown out of them.
And I certainly don't quarrel with that statement whatsoever, Mr. Seif. I basically, from the vantage point of this one solitary commissioner, I believe that the railroad industry has all the tools it needs to solve this problem. And I certainly hope you do it in a way that's collaborative as practicable, and gives people some notice. And there's of course there's a lot of money involved in car design and loading techniques and relationships with coal mines that are of business significance and relationship with utilities. But with all due respect, I think multiple parties here are breathing a lot more nuance into this situation than is necessary. It seems to me to be a pretty simple problem to solve. Obviously, some solutions will cost more than others, but the railroad industry has figured out a way to solve 99.9% of all the other commodity leakage and loss problems over the years. I'm highly confident you can see to it this one gets solved, and maybe I'm just missing something. This is not the proverbial rocket science. Coal's being loaded well above the rim of rail cars in windy, bumpy terrain, and surprise, surprise, some of it's blowing out. And surprise, surprise, it's causing negative externalities, and surprise, surprise, pardon my sarcasm, the railroad industry has decided that that's probably not a good thing, and we should probably adopt more of a no-spill policy. But I'll wind up. But Mr. Weicker, you mentioned contracts, and I understand some of this is sensitive, but you did say that you would expect that in the near future, over the next year or so, if I heard you correctly, your contracts with your coal customers will in fact mirror the tariff that's at issue today.
We are. I'm sorry.
I guess what caught my attention with that is in a contract, we usually see on the few occasions that we get an opportunity to see in the course of our work, rail contracts, which is not too often, those terms, but in other business transactions, contracts tend to be looked at by lawyers, especially if they're new contracts involving the types of money involved here. And the terms and conditions and sanctions or penalties or consequences are usually pretty well spelled out, so the parties know exactly what they're getting into, what they're being held responsible for, and what the penalty, for lack of a better word, would be if they don't meet that responsibility. With all due respect, that's when I read the tariff at issue here, it doesn't read like a contract. It perhaps doesn't have to. It's a tariff, not a contract. But it's rather open-ended. I used the expression earlier about the meet this standard or else is kind of my way of dumbing down the tariff. Do you have any sympathy, or can you understand why your customers might sort of want a clarification on what do you mean by the or else? I mean, because you're basically, this is the only, presumably parties either don't want a contract or can't reach a contract, so they're going to do business by tariff. And there's this pretty important provision that seems to hint at possible negative ramifications to a railroad customer if they don't meet a standard, but those consequences are not explained.
We have, the rule doesn't say or else.
It doesn't say anything. It just says meet this standard, right?
It does. Yes, it does. And it does not say any particular remedy.
Welcome back, everyone. We'll continue the hearing with the third panel, the shipper interests, and we'll start with Arkansas Electric Cooperative Corporation. You have 30 minutes, and you will have then 10 minutes on rebuttal.
Thank you very much, Mr. Chairman. I'm Eric von Salzen. On behalf of Arkansas Electric Cooperative Corporation, with me is Steve Sharp, AEC's Principal Engineer, Fuels and Civil, and we will divide our 30 minutes. On behalf of AECC, and I'm sure I expressed the sentiments of the other shipper parties as well, we thank the Board for commencing this proceeding to consider the reasonableness of BNSF's coal dust tariff. As a result of this proceeding, a great deal of information has come to light about maintenance and operating practices on these lines and the extent that fugitive coal plays a role in those matters. What we have learned leads to the conclusion that BNSF's coal dust tariff is not merely unnecessary, it would in fact be counterproductive. It would increase the risk of disruption to service on the joint line, not reduce it. In this argument, I intend to address the following three issues. The evidence, all right, have I lost my power here? Can I be heard? Thank you.
You're fine.
Okay. First, the evidence shows that airborne coal dust, which is what is measured by BNSF's track monitors, is not principally what fouls the ballast. The fugitive coal that falls onto the track is substantially caused by the railroad's own operating practices and maintenance practices. Spraying toppers on coal cars won't affect that process. Second, I intend to discuss briefly the two derailments in 2005, which BNSF repeatedly holds up as justification for its coal dust tariff, but which were not caused by coal dust. Third, coal dust is not what threatens the safe and reliable operation of the joint line. What does threaten the safe and reliable operation of the joint line is inadequate maintenance. If the board approves the coal dust tariff, that will lead BNSF to reduce what it considers excessive maintenance efforts on the joint line. That's what threatens a repetition of the events of 2005, not the existence of coal dust. Starting then first with the issue of airborne coal dust, BNSF says that it can't tell in advance whether a particular coal train will violate its coal dust standards or not. Coal dust deposition, BNSF claims, depends on complex relationships among a number of factors. So rather than trying to figure out what causes some trains to generate excessive dust while others don't, BNSF wants to impose requirements that in effect would compel all shippers to spray surfactants on all coal cars. Now that's a red flag right there. If BNSF can't figure out what it is about a particular train that will cause an excessive coal dust reading in the monitoring system, then perhaps BNSF doesn't really have an adequate understanding of what the problem is that it's trying to address. I'd like to quote the great Justice Frankfurter, who said, "Putting the wrong question is not likely to beget right answers, even in law," and I would add, even in railroads. BNSF focuses its attention on airborne dust, and what it measures is dust that remains airborne when it reaches the monitor 60 feet away from the train track. Based on a detailed analysis of BNSF's own dust fall data, AECC has shown that such airborne dust accounts only for on the order of 10% of the coal that actually lands on the ballast. You didn't hear that this morning, but it's in the record. Where does the rest of the coal dust that lands on the ballast come from? During the early stages of this proceeding, BNSF's witnesses acknowledged that the deposition of coal dust is particularly found on bridges and switches. But BNSF has scrupulously avoided any consideration of the reasons why fugitive coal deposition would follow the pattern that its own witnesses have observed. And I believe they mentioned it this morning. Now, thanks to the analysis that AECC has provided in this case based on BNSF's own evidence, we now know a lot more about what causes fugitive coal to be deposited onto the joint line track in the pattern BNSF's witnesses have described. We know that to a substantial extent, fugitive coal that accumulates on switches and bridges isn't the airborne dust that's picked up by the trackside monitor 60 feet from the track. Rather, much of it is coal that is shaken out of the cars by vibration as the train passes over rough track or over track where the modulus, the stiffness of the track, changes. That's one reason why you find a lot of coal dust and coal at switches and bridges, because that's where vibrations arise from changes in track modulus as the track goes on and off the bridge or over a switch, and where BNSF has not taken adequate steps to mitigate the effect of such modulus changes. AECC's evidence also shows how deposition of fugitive coal is caused in part by BNSF's own poor maintenance practices on switch frogs, which has been documented extensively in photographic evidence supplied by the railroads. One of BNSF's own videos shows vibration as each car passes over a switch, with minimal other emissions from that train. AECC has documented for the board the fact that BNSF's own dust fall monitors, these are the dust fall monitors, not the ones that are at milepost 90.2, I think, but these are the ones that actually measure the dust as it falls onto the ground. They show much higher accumulations of coal dust on the descending sides of big sags. By big sags, we mean a sustained and pronounced descent followed by a pronounced ascent. These are typically places where the line makes a perpendicular crossing of a valley. The evidence documents an apparent operating practice of running trains fast down the descending side of big sags. One of the videos BNSF cites as an example of high coal dust emissions, in fact, shows a train running down the descending side of a big sag at 50 miles an hour. Even the new table of coal dust accumulation, which is in BNSF's rebuttal, shows that much more coal accumulates on the descending sides of big sags than on the ascending sides of the same big sags and elsewhere. Running trains down the descending side of big sags at high speeds generates much of the fugitive coal that is at issue in this case. The same topographic features that create the opposing slopes of the big sags also tend to move water into the low point. In other words, if you're crossing a valley, you tend to find water at the bottom of the valley. And where you find the water, you tend to find the bridges. On the joint line, AEC's evidence has highlighted how the bridges that BNSF identifies as focal points of fugitive coal accumulation are primarily those near the bottoms of big sags. So in addition to high downhill operating speeds and the resulting amplification of modulus changes at the bridge, AEC has also identified so-called slack action as an apparent causal factor in the deposition of fugitive coal on bridges. A single PRB coal train can easily have 19,000 or more tons of coal and rail cars between the locomotives at the head end and the DPU at the trailing end. At the bottom of the big sag, the train is basically transitioning between a braking mode to a pulling mode to move the train up the following ascent. During this transition, an individual car can move freely for a short distance until it imparts an accelerating motion to the next car in the train. In this process, a repeated shock wave propagates through the train. AECC has identified in the record a BNSF video that shows a mild slack action incident, as well as statements from BNSF's own experts to the effect that slack action redistributes the coal within a rail car, and photographic evidence that appears to show clumps of coal, not airborne coal dust, clumps of coal spilled out of a rail car on a bridge. The evidence indicates that slack action is a factor in at least some of the deposition of fugitive coal within BNSF's jurisdiction. The evidence identified by AEC in this area, and I've only summarized a small portion of it, but I hope I've hit the highlights. The evidence shows, one, most of the fugitive coal on the roadbed results from processes other than the aerial suspension of coal dust measured by BNSF's monitoring system. Only on the order of 10% of the coal dust that lands on the ballast comes from the airborne coal dust. Second, most of the fugitive coal deposited on the track are the result of actions largely or entirely under the control of BNSF as the operator of the line and as the party responsible for maintaining the line, maintaining the switch frogs, maintaining the areas of modulus change, training the crews regarding high-speed operation down descending slopes, and various other methods to minimize slack action. BNSF is trying to hold shippers responsible for actions and circumstances BNSF itself controls. Third, these actions and circumstances would undermine the effectiveness of chemical toppers even if they were applied. BNSF's own evidence shows that high operating speeds and the redistribution of coal in the car can compromise significantly the effectiveness of chemical surfactants. It's not what the toppers are designed to do. They're not designed to hold clumps of coal from being vibrated out of the car by a train that's going 50 miles an hour down a slope and then hit slack action as it goes up. The surfactants are intended to keep dust from drifting off. BNSF is focusing on the wrong issue. Airborne coal dust is not what fouls the ballast. BNSF's tariff doesn't address the coal that falls onto the ballast, and it therefore cannot significantly reduce coal depositions. Secondly, I'd like to turn briefly to the 2005 derailments, which BNSF cites as a justification for its tariff. BNSF, throughout this lengthy proceeding, has presented no real proof that coal dust caused the derailments. They've repeatedly said so in conclusory statements over and over again. Of course coal dust caused the derailment, but they provided no analysis of how those accidents occurred and how coal dust supposedly contributed to them happening. AECC has presented evidence. First, we presented the evidence of Douglas DeBerg, an independent railroad transportation consultant with over 40 years' experience in track construction and maintenance, who inspected the derailment sites and reviewed relevant documents produced in discovery. He concluded that coal dust did not cause the derailments. Poor maintenance and inspection practices by BNSF caused them. And he describes his reasoning in detail. We presented another witness, Michael Nelson, who provided additional supportive insights into the causes of the derailment based on analysis of documents produced by BNSF and UP in discovery. He found that in 2003, UP learned that BNSF had been deferring maintenance on the joint line, and UP encouraged, I choose my word carefully, BNSF to change its practices. BNSF did increase maintenance in 2004, but not enough to prevent the derailments when several years of drought in the area, we heard about that this morning, ended with the return of more normal precipitation in the spring of 2005. Mr. Nelson examined records of communications between BNSF, train dispatchers, and train crews at the time of the derailments. They're classified highly confidential, and besides, they use a lot of salty language, so I'm not going to quote them for you. But in essence, what they show, and they are part of the record in this case, is that rough track had been reported at the location where the UP train was later to derail. A crew was sent to fix the condition. They reported that it had been fixed. The site was tested with a helper locomotive, and then the first train over that stretch of track derailed. As Mr. Nelson said, under these circumstances, it is difficult to imagine how a rational person could ascribe this derailment to coal dust rather than inadequate maintenance practices. Whatever the original source of the rough track may have been, BNSF had forewarning of the problem and ample opportunity to remedy it before the passage of the UP train. At the other site, Mr. Nelson found that it had been scheduled for undercutting in 2004, but this was not done. As Mr. Nelson said, as was the case with the UP derailment, BNSF knew in advance there was a problem. Its references to coal dust do not alter the fact that it failed to perform maintenance it knew was needed. There's a lot more evidence like this in the record, but I want to focus on evidence from BNSF about where coal dust gets deposited on the track. Because although BNSF's rhetoric would lead you to think that the entire joint line is covered with coal dust, in fact, their evidence shows that much more coal dust is deposited in certain locations than in others. BNSF's own data, including the dust bowl jars and the CRA assessment that was presented in rebuttal, show that the coal dust accumulations on the downhill sides of big sags are much higher than they are on the uphill sides. This is confirmed in BNSF's final evidence in this subject, the chart of dustfall concentrations on page 4 of Mr. Emmett's rebuttal verified statement, which I commend to your attention. This is significant because each derailment occurred on the uphill side of a big sag. How could coal dust be the cause of the derailments if the derailments occurred where coal dust accumulations are near or at their lowest level? Before the derailments, BNSF was already beginning to develop plans to impose dust suppression obligations on PRB coal shippers. When the derailments occurred, it is apparent that BNSF decided to use those derailments to strengthen its rhetoric against coal dust and obscure the fact that BNSF had deferred maintenance to the point that the only thing keeping substantial portions of the joint line infrastructure stable was a lengthy drought in eastern Wyoming, which ended in the spring of 2005. And when rainfall returned to near normal levels, the derailments happened. The third point I want to stress is that coal dust is not the problem. Inadequate maintenance is the potential problem. For the last 5 years, we have not had a derailment on the joint line because BNSF picked up the pace on maintenance of that line. So we have not had a derailment so far. But BNSF desperately wants to cut back on its maintenance expenses, failing to recognize, we saw these statistics, I think, from DOT this morning, this is the highest density rail line in this country and perhaps in the world. And it has grown at a phenomenal rate from 1984, 76 million tons, to 2008, 375 million tons of traffic on that line. A huge volume of traffic, a 3- and 4-tracked line. There's a train that goes by, I think it's every 12 minutes. It's an incredible growth of traffic, and of course, with that level of traffic, you need a high level of maintenance effort, because it's the traffic over the line that makes the rails wear out, the ties wear out, and particularly that stresses the ballast, causes ballast to break down, and requires undercutting, track surfacing, and so forth. One of the most striking things about the testimony, I think this is in BNSF's reply testimony, is to read the testimony of Mr. Sloggett, General Director of Maintenance at BNSF, and Mr. Smith, General Superintendent of Transportation for the Central Region, who talk about the fact that they are just barely now keeping up with the maintenance requirements on this line. They're talking about having 14 months of work to do and only 7 to 10 months of working season to do it in. They're talking about inspectors being on 40% overtime at times. BNSF is barely keeping up with the maintenance demands on this line, and they desperately want to be relieved of those requirements that come with the blessings of all the revenues that they get from all the traffic. And they think that by getting this board to approve their coal dust tariff, they'll be able to save tens of millions of dollars in maintenance efforts every year. If they do that, it's what they did prior to 2003, and we know where that resulted in 2005. Coal dust is not the problem. Maintenance is the problem. The last thing in the world for this board to do is to encourage the BNSF to believe that they can go back to the bad old days and cut back on their maintenance efforts. Thank you. Mr. Sharp will now address the board.
Thank you. I'd like to follow on from Mr. Von Salzen's last point and respond to BNSF's assertion that coal shippers must be forced by BNSF and its tariff to act responsibly with respect to coal dust. The fact is that PRB coal shippers have made tremendous investments to enhance the efficiency of coal transportation, such as purchasing aluminum car fleets and constructing longer unloading facilities at our power plants to support longer trains. I think even BNSF acknowledges that coal shippers have improved the maintenance of coal cars, which reduces coal loss through the sides and bottoms of those cars. We have adopted the profiling of the top of the coal surface as recommended by BNSF and as it's been revised and it certainly may be revised again. We are happy to work with the mines and try to accommodate that and accomplish what coal dust reductions may come from that. Many shippers have changed over to the use of larger coal sizes, which is also believed to reduce fugitive coal dust. From day one as a coal user, AECC has willingly invested substantial resources to improve productivity and lower the railroad's overall cost of transporting the coal we use. But we and other coal shippers oppose the BNSF tariff for two reasons. First, as discussed by Mr. Von Salzen, coal shippers do not want to provide BNSF an excuse to cut back on the maintenance of the joint line. We believe that's where the real risk of service disruptions lies. Second, coal shippers don't want to waste money, either ours or anyone else's. We do not believe that spraying toppers on coal cars is a prudent way to address the coal dust issue. We urge the board to reaffirm the principle that minimizing overall costs is a central objective and reaffirm BNSF's statutory duty to maintain the performance capabilities of its infrastructure. If the board does so, this will provide a sound framework within which shippers and carriers can work cooperatively towards solutions that minimize total resource costs. AECC, like other coal shippers, is ready to participate in reasonable efforts to improve the efficiency and reliability of the joint line, including reducing fugitive coal dust. Coal shippers have done so already, as I've mentioned. It is possible that cost-effective measures can be developed to reduce fugitive coal dust, including changes in operating and maintenance practices of BNSF and UP, and through identifying what causes some trains to generate a lot of airborne coal dust. AECC favors cooperative and voluntary action by railroads and shippers toward that end. But the BNSF coal dust tariff takes us down a dead-end road. Spraying surfactants on tops of coal cars will not prevent coal dust from being deposited on the track, but it will encourage BNSF to do what it desperately wants to do: cut down on the expense of maintaining this extremely high-density rail line. The continuation of safe and reliable rail service on the joint line would be fostered by disapproving BNSF's coal dust tariff. It would also be a good first step towards starting a cooperative process among coal shippers, mines, and railroads to improve the maintenance of the joint line. Thank you.
We are done. I guess we're the first
Great.
party to use less than our allotted time.
I congratulate you. Yeah, that might be an all-time first. Thank you very much for your presentation. And now we will have a presentation from the Western Coal Traffic League, and you have 10 minutes.
Thank you, Mr. Chairman. My name is John Lasser. I'm appearing here today on behalf of the Western Coal Traffic League. The Coal League is an organization of utilities that ship coal mined west of the Mississippi River. Currently, the Coal League membership transports approximately 140 million tons of coal annually. Coal League appears here in support of AECC's request that the board find BNSF's proposed coal dust standards constitute an unreasonable practice. The Coal League, along with a group called the Concerned Captive Coal Shippers, has submitted extensive evidence in support of a finding by this board that the tariff is unreasonable. I'm going to refer to the filing jointly made by the Coal League and the Concerned Captive Coal Shippers as the coal shippers filing, since that's the terminology we use to describe ourselves in our filings. One of the points that BN made repeatedly in its written comments to this board was that its proposed IDV standards are supported by sound science. And coal shippers put in substantial evidence supported by a number of experts demonstrating that the proposed coal dust standards are not supported by sound science. And what I'd like to do in the time allotted to me today is to hit some of the high points in our testimony. Oops, oh, I aim this thing at. There we go. First of all, what we're talking about here are two BNSF tariff items, and they both provide that effective October 1, 2010, coal shippers transporting PRB coal trains over the joint line or the Black Hills line need to meet specified what they call IDV2 standards. The cap on the joint line is 300 IDV units, and the cap on the Black Hill subdivision is 245 units. And returning to our theme of sound science, we believe the first principle of sound science is that if a party is going to be making studies and proposing standards, that folks that are impacted by that should be able to replicate the study procedures, replicate the study results, understand how the calculations are made for a number of purposes. One, to see whether they're any good. Second, possibly to restate them. And the BN's calculations all reside in a computer program put together by one of its consultants. The IDV standard is one the BN made up. It doesn't exist anywhere except on this computer program. In discovery, in this case, coal shippers asked BN to produce the program. BN refused to do it. Without the program, we can't replicate what BN is doing. We can't understand it. Our experts can't adequately critique it. We certainly can't restate it. And as one of our experts noted, what we're dealing with here is a classic black box. And we submit that in a case involving potentially the expenditure of hundreds of millions of dollars in compliance costs, it's unreasonable for BN to refuse to turn the program over. And certainly if we don't have it, we can't share it with you. And the board also can't figure out what this IDV standard is all about. And we would point out in analogous contexts in cases where computer programs are used to generate evidence, the board has consistently ruled that if a computer program is introduced, the other side needs to turn over the program so that the opposing sides can review the data and review the answers. Now, the next sound science point I'd like to hit on is a basic point that sound science requires use of study data suitable for its intended purpose. The principal input data in the BNSS black box IDV calculations is E-sampler data. The E-samplers are located at milepost 90.7 on the joint line and milepost 558 on the Black Hills subdivision. The asserted purpose, according to BN, of the E-sampler data is to measure accurately coal dust deposited in the ballast by each passing train. And as our evidence demonstrates, the E-sampler data is simply not suitable for this purpose for three principal reasons. First, the E-samplers are located at a minimum 60 feet from passing trains. They're not measuring coal dust being deposited in the ballast. Secondly, the E-samplers, as they're set up, measure all particulates in the air when the air is being sampled. It could be dirt, could be diesel soot, could be bugs, could be other particulates, but it's not just coal dust if there's any coal dust there. And third, the E-sampler output used by BNSF is not being developed correctly. The E-samplers that BNSF has purchased can measure particulate concentrations using two methods, a laser or light scatter approach or a gravimetric filter approach. It's generally recognized, or it's actually universally recognized by experts in the field that when you're measuring particulates using lasers, you may not get accurate results because of limitations in the technology. On the other hand, experts in the field all recognize that if you measure particulate emissions using filters, you will get accurate answers. So, for example, EPA and most of their air monitoring uses the filter approach. And in these E-samplers, the purpose of the filter is to provide a check or reference standard to make sure the laser results are accurate. Now, BNSF isn't using the filters, claims it's not necessary to do so. BNSF has presented no studies demonstrating when they're measuring particulate emissions in the Powder River Basin that the laser methodology will produce accurate results and they don't need to use filters. Coal shippers, on the other hand, presented extensive evidence primarily through Dr. Mark Viz, one of the nation's leading experts on coal dust emissions, demonstrating it's absolutely essential if you're going to use data from one of these lasers that you check the data against a known reference standard. If you don't do it, you have no idea what you're getting out, and basically there's no way in the world to determine whether the data itself is accurate or not. And the last sound science point we'd like to make involves BNSF's so-called variability analysis. BNSF performed a number of what they called side-by-side tests, where they put two E-samplers next to each other in order to attempt to measure a common particulate emission. Sometimes they had a common air intake, and basically they would have these side-by-side tests. They developed IDVs. They're basically trying to see whether the same two machines would produce the same answers. And what they found was, in most cases, they weren't, and they could produce wildly different answers. For example, you could have, in one of these side-by-side tests, one E-sampler, when you take the output from that, run it through the IDV formula, produce an IDV of 50. You take the second paired E-sampler and produce an IDV that's 10 times higher. It's roughly equivalent to a police officer having two speed guns in his hand in the car going down the road. One registers the car is going 20 miles per hour, the other registers going 120, and you really don't know which one is correct. To address these variability results, BNSF attempted to run a regression of approximately 400 side-by-side pairs. And based upon this regression, the BN concluded that if IDV is 300 or higher, there's a 95% chance that the IDV actually being the train actually possesses is above 134. The variability analysis is severely flawed. Our experts have put in a substantial amount of evidence on this. Our basic problems are, again, you're using an IDV formula we don't understand, which ties into the regression. The data going into the IDV calculations is unsuitable. We also took a pretty close look at the data pairs BN was using, and while most of this data is stamped confidential or highly confidential, our experts concluded from a statistical standpoint the vast majority of paired data that BN was using is not suitable for this purpose. And there's no number of other problems with BNSS regression that our experts discussed in their testimony. So from the colleagues' perspective, focusing exclusively on the IDV standard, we submit the board shouldn't approve it for three reasons. One, the underlying program wasn't turned over. Two, the input data going into it is severely flawed. And three, BNSS variability analysis also was done in a very non-scientific manner. Thank you.
Thank you very much, Mr. Lasser. And now we will hear from the concerned captive coal shippers. Mr. Loftus, you have 10 minutes.
Thank you, Mr. Chairman. My name is Michael Loftus. It's my privilege to appear this afternoon on behalf of the concerned captive coal shippers, the members of which appear on the projector before you. Each of these companies is a large consumer of coal and relies upon rail transportation to move that coal from power to their power plants. I would ask you to note that several of these entities are eastern utilities and are involved in this proceeding because of their concern about the implications for their traffic if the board were to approve the proposed tariff items at issue in this proceeding. I intend to focus primarily on one area of the evidence and arguments submitted by the coal shippers, and that has to do with the comparison of the costs of dealing with coal dust through spraying all PRB coal traffic as opposed to through traditional maintenance. But first, I would like to show a very brief video clip, and you saw this morning a clip from BN or 2 that showed a lot of dust blowing off of trains on the joint line in the Powder River Basin. Here you see a train that is not emitting any visible dust. This came to us in the form of production and discovery by BNSF. We submitted this along with several other clips of similar scenes in our rebuttal evidence. We also submitted a number of photographs that we had taken at various stages over the joint line, and I'd like to just flip through those quickly to show you that although you might, based upon what you heard, think that the entire joint line is covered with black dust, as you go through these at various mileposts throughout the joint line, you see what appears to be clean and ballast and otherwise good condition. Returning to the point that I want to focus on, namely comparative costs, the coal shippers have developed an extensive analysis of the costs of dealing with coal dust through traditional maintenance techniques, and we are talking about costs here in our estimation. This case, we believe, is largely about BNSF's efforts to shift maintenance costs onto its coal customers. The costs for spraying coal trains originating in the PRB, as we have calculated them, are multiples of BNSF's costs to deal with coal dust through maintenance procedures, such as vacuuming, shoulder cleaning, and ballast undercutting. The actual numbers, which are confidential, appear in coal shippers' rebuttal argument at page 5, among other places. From a public policy perspective, the board should find unreasonable a tariff requirement that seeks to deal with coal dust at a significantly greater cost to shippers and to society at large than BNSF's costs to deal with coal dust through normal maintenance activities. Applicable agency and court precedent support the board's consideration of the economic efficiency of a tariff-imposed requirement such as those at issue here. DOT, as you know, has affirmed the principle that coal dust should be dealt with in the most cost-effective way. And it also, as I read it, accepts either maintenance or spraying as an acceptable manner of maintaining the ballast in a safe and satisfactory condition. Coal shippers and BNSF have both presented calculations, but they are substantially different. I'd like to focus first on the cost of spraying, but I'll say that as to both types of costs, the spraying costs and the maintenance costs, the coal shippers have relied primarily on materials obtained in discovery from BNSF. BNSF, by contrast, has backed away from the materials they produced in discovery and utilized a number of new and we believe arbitrary assumptions about costs that have, not surprisingly, substantially increased the amount of their cost estimates. For the cost of spraying, coal shippers expert relied on an extensive analysis of the cost of spraying coal throughout the basin that was produced by BNSF in discovery, and that was not developed for litigation purposes. BNSF and UP have based their costs of spraying on what I would describe as guesstimates from their employees, for which no support has been provided when you review their testimony. Turning to maintenance of way costs, coal shippers have again relied primarily on analyses of coal dust related maintenance costs obtained from BNSF and discovery. BNSF disavows those studies and utilizes a number of new arbitrary assumptions. It is widely acknowledged that ballast contains other ballast contaminants, such as breakdown of ballast in concrete ties, dirt, brake shoe dust, traction sand, etc. It was striking to me this morning that the railroad panel completed their prepared remarks without any mention of any contaminant other than coal dust. It was not until Vice Chairman Mulvey asked a question that there was an acknowledgement that there are other contaminants in the ballast. One of BNSF's own witnesses stated, and I quote, "To assess the impact of coal dust in ballast, it is also important to know what other contaminants are present and the amount of the other contaminants." That's Van Hook reply, verified statement at page 11. Yet BNSF has not submitted any comprehensive analysis of the amount of different contaminants in the ballast of its PRB lines. Nor has BNSF analyzed the rate of accumulation of other ballast contaminants. Instead, BNSF simply assumes that all additional coal dust related maintenance is caused solely by coal dust and that all these other contaminants don't have any contributory effect and share in the causal element. I'd like to close by addressing briefly the precautionary principle. Now first, BNSF only introduced this concept in its rebuttal testimony. As a result, we have not had an opportunity and there is no responsive expert testimony addressing the point. If you review the rebuttal statement of Colt and Mitchell, a few things are very clear immediately. First, they accept as gospel virtually every single element of BNSF's evidence and reject uniformly all opposing evidence. The most critical fact that they assume is that the maintenance option is incapable of assuring safe and satisfactory ballast conditions. I believe that is simply incorrect, and that because maintenance is capable of maintaining a safe condition, that the board must consider the relative costs, and when it does so, it should find the standards unreasonable. Thank you.
Thank you, Mr. Loftus. Now we'll hear from the National Coal Transportation Association. Mr. Wilcox, you have 10 minutes.
Thank you, Mr. Chairman, Mr. Vice Chairman, Commissioner Nottingham. This hearing testimony, as was NCTA's written statement, is presented on behalf of the NCTA and its board of directors. The executive director of NCTA, Mr. Tom Cantor, who I think you all are familiar with, is here at the hearing in attendance. NCTA is a broad-based association of coal industry stakeholders based in Denver. It's has 140 members, and they include virtually all the parties of record in this proceeding, including the petitioner AECC. But NCTA's participation in this proceeding has been limited in scope and purpose, and which is the inclusion of facts related to the coal ballast issue and also relevant aspects of a NCTA-sponsored scientific study on coal dust suppression into the record of this proceeding. NCTA's written submission describes how since 1973 NCTA has served the role of an educational organization, a facilitator of solutions of coal transportation issues west and east. And its efforts have included all stakeholders, including the Class I railroads. NCTA has been involved in the overall coal dust issue from the beginning, when it actively worked with BNSF, UP, and NCTA members to deal with the impacts and aftermath of the joint line derailments. And also BNSF, I think in the person of Mr. Fox, first announced that BNSF was exploring coal dust suppressants on coal cars in NCTA's annual meeting in the fall of 2005. When BNSF announced in 2006 its intention to formally adopt a performance standard requiring 85% of coal dust emissions from coal cars to be eliminated mostly through chemical spraying. This is the IDV 300, the beta version of the current standard, the IDV 2 standard. Doubts and concerns among NCTA's members, and then also BNSF's decision to stop participating actively in a joint effort with NCTA led NCTA to eventually commission an independent study of the coal dust issue by Exponent, Inc. And the study was funded by NCTA members, and the final study was submitted in August 2009, entitled Railcar Loss and Effectiveness. In its final form, the study scientifically evaluated the performance of a variety of dust suppressants sprays, and in doing so also evaluated and analyzed the coal dust monitoring methods BNSF had employed along the joint line to enforce its standard. NCTA it produced the Exponent study to parties in the discovery phase of the proceeding and has attached key portions of it to NCTA's written statement to add to the record of this proceeding. I'm going to highlight three basic points from the written statement. First, NCTA was and is keenly aware of the significant cost-shifting legal and public policy issues associated with BNSF's proposed standard, and its original study scope included some of those issues, particularly the costs and benefits of various means of controlling coal dust ballast fouling. However, as our statement explains, primarily due to budgetary constraints, and because NCTA's goal was to try to contribute to an industry solution to the overall ballast problem, NCTA narrowly focused Exponent's efforts on some small pieces of the overall issue, and that included the testing the ability of the chemical sprays to contain the coal dust and then critiquing BNSF's methods. Second, based on data from field tests of a limited number of coal trains, the study did conclude that the tested suppressants, I think there were 9 or 10 of them that were tested, did in fact control coal dust blowing off of coal cars with varying degrees of success. However, the study also concluded that even if the 85% goal was met for a particular train test, that didn't necessarily mean that correlated with compliance with BNSF's standard due to this IDV 300 standard due to monitoring problems and data deficiencies. Third, the Exponent study identified in the second part of its mission, limited mission, which was to critique the methods BNSF was proposing to enforce compliance. It's a standard that Mr. Lasser talked about. It raised numerous concerns and questions about the methods and devices BNSF was using to measure the enforcement of its proposed standard. The TSM array that they're using along milepost 90.7 and the various collecting devices. These concerns, which were put in the initial report to NCTA, have been repeated and elaborated upon by Dr. Viz in his verified statements submitted on behalf of WCTL and captive coal shippers. In conclusion, while necessarily limited in scope and purpose, NCTA believes that the exponent study nevertheless does provide the board with some relevant and useful information about the effectiveness or non-effectiveness of using chemical sprays to actually control the loss of coal dust. And it also provides the board with a summary, well, more than that, but a discussion of the issues and concerns identified by exponent for NCTA concerning the means by which BNSF would attempt to accurately and reliably measure and enforce its standard. One final point in response to a statement by Vice Chairman Mulvey on the objectivity of experts. I would note that exponent was hired at a time when this proceeding was not underway, and NCTA is traditionally a non-adversarial association, and so I do believe that it's not a study prepared in anticipation of litigation, so I think it is afforded a degree of objectivity, a little more than if it was. So, thank you.
Thank you, Mr. Wilcox. You also get a gold star for beating the clock. Now we will hear from the American Public Power Association, Edison Electric Institute, National Rural Electric Cooperative Association. Mr. McBride, you have 10 minutes.
Thank you, Mr. Chairman, Mr. Vice Chairman, Board Member Nottingham. I do want to start by saying that it probably bears reminding everyone that we are the best customers of the railroads. Mr. Rose is quoted in the record as admitting that coal is their most profitable commodity. We've been accused of being dumpers, litterers, and trespassers in this record, and I think it's important from a legal standpoint to realize that our traffic is on the railroad lines by their consent. And therefore, we cannot be in legal violation under any of those doctrines. Board Member Nottingham, you asked a very important series of questions this morning. Wanted some commentary on how it was that the coal cars got to the point where coal was coming off or spilling from the cars. And it occurred to me that you might benefit from a little bit of history here as to how this all came about. In the 1990s, as you all know, the railroads went through a series of mergers. Some of them were not very successful from an operational standpoint. Wall Street was not happy. Wall Street put a lot of pressure on the railroad boards and CEOs to cut back on their capital expenditures. Some of the railroads resisted better than others. BN and Mr. Krebs tried to resist, but those pressures applied to this whole industry. And at the same time, the economy was booming and coal demand was increasing. And my clients and everyone up here's clients wanted as much coal as they could get, especially from the PRB, because it's the clean air compliant coal of choice. And as a result, by 2003 to 4, as I think you all know, there were capacity constraints in the Powder River Basin. The railroads were in a very happy situation. Rates were going up. That's not the object much of today's discussion, but they had more demand than they had supply for their transportation. Everyone wanted to move as much coal as they could move. The railroads dictated the loading requirements. The railroads even imposed a 4-hour rule to load a train of as many as 135 cars. If you think about it, that's not very much time. And as a result, it's not surprising that coal would be out over the tops of the cars, on the sills of the cars, over the sides of the cars. You'll also hear acknowledgement on the record earlier today from BNSF that some of these cars are the railroad cars. And more coal in many cases is coming out of the bottoms of the bottom dump cars than out of the tops, because the railroads are not doing as good a job of maintaining some of those cars as we do of ours. We have to maintain our cars according to their standards. So we got to this situation because of a whole confluence of events. People learned from them when those derailments occurred. The loading profiles are better. You've heard about that. UP's talking about mechanical suppression. BN didn't do adequate maintenance because it was moving all the coal trains that it could move. You've heard a lot of evidence about that. I don't think there's any question about it. And the FRA in its studies of what caused those derailments blamed inadequate welds, too wide gauge, inadequate maintenance, inadequate inspections. There's no doubt about it. That's what your sister agency concluded. I'm surprised they didn't come here and testify about it, but that's what happened. Everybody's moving on from there. But BN is trying to blame its customers for the problems that it itself created on its own property. That's what happened. Now, even older history, which I think is terribly important for you to know, and forgive my voice, I've been ill, but I got up for this because I realized that we're reliving a little bit of history here. 30-some years ago, the railroads tried to refuse to carry our nuclear materials. And the ICC stepped up to the plate and said, you can't do that. And the Sixth Circuit affirmed in the Akron-Canton case that you've seen cited in the record and agreed with the D.C. Circuit that the ICC should defer to its sister agencies, including the DOT, as to and accept the FAA DOT positions on safety as establishing both an inner and outer limit on its safety jurisdiction. That was relying on the D.C. Circuit's opinion in the Delta Airlines case. Then we got to the D.C. Circuit after the railroads tried to impose special train service on us. They said, we're not carrying your nuclear materials unless we can impose special train service, which the D.C. Circuit noted in the decision of Conrail versus ICC. It's cited in the record, 646, Fed Second at 642, and I would urge you to read both of these decisions. The first one I cited, Akron-Canton, 611 F Second at 1162. Please read especially Conrail v. ICC, 646 F Second, 642. The Court of Appeals went on at great length about the law here. It noted that DOT, and in that case the Nuclear Regulatory Commission, had not required special train service. It adhered to the ruling of the Sixth Circuit that I've just described to you, which followed an earlier D.C. Circuit ruling. And it said that when DOT and NRC did not require special train service in that case, a presumption arises against a presumption arises that expenditures for safety measures not specified by those agencies are unnecessary and fail to satisfy the criteria of reasonableness. That discussion's at around page 648. It goes on. The court held that a particular safety measure must produce benefits commensurate with its cost and be economical in order to be reasonable under the statute. Later, the court said there was a presumption, it concluded, against special train service arising from both the DOT NRC regulations, and they believed that the commission should have taken those regulations into account. And the court finally concluded that the railroads failed to present concrete evidence that safety benefits accruing from special train service would be significant enough to match its high costs. It's this case all over again. It reminds me of a story about a wonderful old lawyer named Charlie McCarthy, who used to practice here. He was general counsel of the TVA before that, and he once told me about a farmer in Tennessee in the 30s who used to represent, a lawyer who represented farmers in Tennessee in the 30s whose mules were being taken by courts under the doctrine of replevin because they couldn't pay their loans. And one week he was in defending a farmer whose mule was going to be taken, and the judge ruled against him and in favor of the lender, and the next week he was back again representing another farmer. Made the same argument all over again, and the judge said, sir, weren't you in here last week making the same argument against replevin? He said, oh, yes, sir, but that was a spotted mule case. He said, well, you see, in other words, any case can be distinguished slightly on its facts. But this case is, the radioactive materials cases, if you will, are the spotted mule cases. The law is under the doctrine of reasonableness under the Act, that you may not uphold a railroad safety standard that FRA or DOT have not imposed on the railroads unless it's reasonable, and its benefits have to be in excess of its costs. And I put a bunch of questions into the record with my opening filing, and I would urge you to think about this case in this sense. If this standard that BN was proposing was a proposal in a notice and comment rulemaking proceeding, would you three be comfortable with adopting this standard and asking the Court of Appeals to uphold what you did? We don't even know where the standard came from. You've heard a lot of evidence about that already on this panel. But you couldn't do that. You don't have the program, you don't have the data, you don't know if it's reliable. So you couldn't defend it. And I think that the special train service case that I've cited to you and the earlier Akron-Canton case stand for the proposition that you have a duty to require the railroads to overcome a presumption against additional safety precautions when they seek to impose those kinds of costs on us. And they haven't met that burden. It is their burden. They've tried to argue in their papers, that it's our burden because, we're the petitioner. Well, they've asked for declaratory relief along with Arkansas Electric. Or because we're asking that this be declared an unreasonable practice. No, the D.C. Circuit held in the Conrail v. ICC case, it is their burden when they seek to impose additional precautions on us to justify those standards. And they can't do it when they won't bring in the program, when they won't produce reliable data, when the data they've produced is suspect, when we don't even know what we're measuring. So I would urge you to think hard about whether this is the right way to go about this, to have a monopolist put in its tariff what the standard will be and then tell you to trust them. When they're trying to shift their costs onto us, that's what they're trying to do here. It's not reasonable, it's not right, and you're the only people who stand in the way of keeping them from doing it. And we urge you to do that. Thank you very much, Mr. Chairman.
Thank you, Mr. McBride. Thank you, panel. Now I think we'll have a few questions here. I don't know exactly how you want to answer because obviously I just encourage you not to give the same answers since you have so many clients represented here today. But it sounds like you're a little organized in your presentation. My first question is earlier in the proceeding I was asking Mr. Weicker from BNSF if they were willing to do an activity-based standard here, which would be, I think, logically surfactants. And let's say, hypothetically, we found this to be unreasonable. They put in an activity-based standard, surfactants at a sufficient level, and then that would be enough. And if you do that, there wouldn't be any need for enforcement because you've satisfied what's required in that instance. Would that hypothetical appease the shippers in this instance?
Try a shot at that.
Sure.
Speaking, I think, at least for my client, no, it would not, because the activity that would be mandated or would be an option is still not going to solve the problem. It's still going to be a waste of money. And the practical effect of what BNSF is seeking to impose here is to require everybody to use surfactants. I mean, they say it's a performance-based standard, but the fact of the matter is the only way that anybody's going to be able to satisfy BNSF is if and they've made this quite clear, if you send a train past their monitoring site and the bells and whistles go off, they're going to take you aside in the back room and tell you got to spray. I mean, that's how they enforce it. And so I don't see that it would make any benefit whatsoever.
So, in hearing your answer, I think the hypothetical would assuage you with respect to, the compliance and the enforcement issues. But what you're saying is that the unreasonable part in that situation would be just the fact that spraying surfactants would not be reasonable in itself, just because it just wouldn't be effective.
It would be effective, and also we have to recognize that according to BNSF's own data, only 14% of the trains that pass their monitoring site are in violation of their standard. And yet they have a program here that's intended to require all the cars on all the trains to be sprayed.
What I've struggled with here is BNSF has imposed this tariff, and based on the science that I'm hearing from the shippers with respect to surfactants and whether or not coal dust is such a pernicious has such a pernicious effect on the ballast. What I'm concerned about is why are we here if the science is not accurate? And I mean, why would BNSF be doing this other than that they felt that this was a reasonable thing to do? Is there something I'm missing here, that there's a reason otherwise that they're doing this that you can surmise, Mr. Loftus?
Mr. Chairman, they spend a lot of money on maintenance, and well, they should, because they haul a tremendous amount of coal over these tracks and they make a huge amount of money doing it. But they'd like to stop paying so much for maintenance, and they'd like to simplify their physical maintenance operations and shift those costs to the coal shippers themselves. That's why they have a very strong financial and operational motive to do it, regardless of the merits of their proposal itself.
So if I'm following your reasoning, they would be shifting the cost by requiring the surfactants to be put on, and then that would decrease maintenance. And that's the thought why we're here today.
That is correct from my perspective.
Okay, and yeah,
may I respond just a little further to that?
Sure.
There's a principle in good regulation, seems to me, and it's applicable in good business too, and that is that the person who benefits ought to be the one who bears the costs. You've got an asymmetry here where the monopolist is trying through his tariff to impose on the customer costs that the monopolist then won't have to bear and they will benefit from. Now, let's just analogize for a minute to something the three of you, I think, and your staffs are acutely aware of. PTC. Congress is imposing a requirement that the railroads put on PTC on a good bit of their networks. That's still in flux, of course, and still being argued about. But the railroads are arguing that the costs are something like 10 times the benefits. They have a great incentive to either get the costs down or try to show that they're right, that the benefits don't equal the costs when they're bearing those costs. They have no incentive here to get the costs of spraying down or otherwise control the dust, whether it's through profiling, mechanical suppression, as UP talked about, reducing the amount of coal in the car, Board Member Nottingham, whatever it may be, because we end up bearing those costs. You should be very concerned here that the people who are trying to benefit from this are not the people who are willing to bear the costs.
And I guess my last point, on this line of questions is, with respect to my first question about the hypothetical I had and the answer being the surfactant is the unreasonable part, it seems to follow then that if they're using it to save on maintenance, that the surfactant is having an effect in decreasing the maintenance. So, I mean, it still seems like that there is some reason behind what they're doing here. If they're using the surfactant, it's cutting down on what they're trying to do with the coal dust and the maintenance, that there is some reason behind that. Do you care to respond to that? It'd be good because it addresses what you said.
It's the issue that I was trying to stress. I think when they started all of this, BNSF may very well have believed that they would get a big bang for our buck in terms of reduced maintenance expenses. But the fact of the matter is the evidence, as we've analyzed it, is evidence from BNSF.
We lost you.
Hello? It's evidence from BNSF itself that most of the fugitive coal that falls onto the track and fouls the ballast isn't the airborne stuff that would be prevented by the surfactant. So we end up wasting our money. And the fear on our side is BNSF may very well believe stuff that isn't true. That may be the answer to your earlier question. They may believe it, and they may cut back on their maintenance because they say, oh, the coal dust is gone. Now we don't have to resurface. We don't have to clean our ballast as often as we used to. And they're going to turn out to be wrong, because most of the coal dust, most of the fugitive coal is still going to be there. And the other contaminants, which they didn't mention at all this morning, they're all going to be there. And we're going to get 2005 over again.
Okay, so I'm following what you're saying. The disconnect is not in the logic that you're putting forward. I mean, in your view, the disconnect is more with the science, is what I'm hearing.
We're all of us imperfect, and BNSF is a human institution. I think they're mistaken. I don't think they're evil. I think they're mistaken, but their mistakes could lead to terrible consequences.
Just on another line of questions, with respect to the cost-benefit analysis that I saw kind of in the various filings, my only concern about the cost-benefit analysis was its failure to take into consideration capacity constraints with respect to maintenance. Is there any reason why that wasn't taken into consideration? Or I know it was said it was, I guess it couldn't be, you couldn't evaluate those numbers and come up with something, but is that everyone's position in this matter, that wasn't possible?
Well, if I may address it first, and others
Sure.
might care to comment. There are two reasons it was not included. Number one, it is not a maintenance expenditure and a maintenance cost in that traditional sense. Obviously, when you must perform maintenance on a line, it is not available for other use, or at least during the window when the maintenance is being performed, and so on. It has been ever thus, and always will be. And so it's just a normal operating consideration in operating the railroad. Now, there's another reason, and that is that, the carriers, BNSF, did not submit any comprehensive analysis of what the costs actually were. It had some very generalized plug numbers in, but they were not well defended. And in fact, if you look at their rebuttal filing, when, as part of their precautionary principle shift, they decided, they'd say, well, it would really be hard to try and figure out how much that would cost. And it would be hard to figure out how much of any given maintenance window was really attributable to the coal dust, instead of all the other ballast contaminants or whatever might be involved in making the in performing the maintenance and so on. So they themselves acknowledge that it's hardly clear what those, quote, capacity costs are.
Mr. Chairman, it's also the case that since 2008, coal demand is down, and I believe there's excess capacity out there.
And my last question, I've heard the term cooperative effort kind of bandied about in this proceeding. Do the shippers see any benefit in some type of cooperative effort here to reach a solution? And if so, if there's any suggestions, that would be nice to hear also.
I'll be happy to take a crack at that first, because in each of my filings I mentioned to you that there are voluntary efforts ongoing between the shippers and the carriers and the mines here. There have been several meetings, I think BNSF alluded to some of them this morning. People have been talking to them. Some people have been spraying. People are making their own choices in these matters. We don't discourage those. We encourage those. This has been a cooperative venture in the Powder River Basin, as Mr. Sharp earlier mentioned, for a long, long time. You have the AAR committees and rules, which I think the board members asked about this morning, where the cars are designed in accordance with specs that people at least get to talk about, even if the railroads are the only ones that get to decide. We load in accordance with their requirements or their dictates. We work with the mines on how things are loaded. And as I've said to you, and it volunteered, that some people are spraying and they don't want to be interfered with in doing that. They want to help work this out. I think that if I were in your shoes, I'd wait for a while here and keep this open and see whether any of these things that are ongoing might actually be more productive than just letting BNSF bring down the hammer on us as of October 1 or whatever and say, thou shalt do it the way we want you to do it. We all have a stake in this, and I frankly think it's inappropriate for the party that gets to publish the tariff to tell everybody else how to do it. That's why you're here.
Let me add, of course, NCTA was part of a collaborative effort with its members and UP and UP to a lesser extent, but BNSF when the derailments occurred and in the immediate aftermath. And there were several committees set up which are described in our filing to talk about the ballast fouling issue in terms of not just spraying, but in terms of other measures that can be taken. You know, some of the mechanical measures that have been discussed here in terms of profiling in cars and things like that. And those discussions sort of tailed off around the 2006 timeframe when BNSF announced its first IDV standard, which was very heavily emphasized on using suppressants, and that put I guess, for want of a better term, a chill on the discussions. And then it's with this amount of stakeholders, it's hard to get a consensus in the first place. So you had NCTA members who were actively involved in the discussions about a variety of measures. We're not excited about specifically focusing on suppressants. And but Mr. McBride is correct. BNSF, to its credit, did participate in the exponent study by helping set up the trains that were used in the on-road testing that were part of that study. And testing is occurring today, so it's ongoing. But of course, NCTA would welcome a more collaborative effort to have an industry solution.
I would say on the part of the Western Coal Traffic League, Coal League first got involved in this when the president of the league sent a letter to the BN and the UP. We saw this tariff coming, and we said, perhaps we could discuss, rather than having something rammed down our throat, an approach where both the costs and the benefits might be shared. As I recall, we received no response from the BN, and the UP said they couldn't talk to us because it would be violating the antitrust laws. So the olive branch that we extended didn't go very far.
Thank you very much. Commissioner Nottingham?
Thank you, Mr. Chairman. I guess if I could just quickly go down the panel and see if we could find some common ground of something that we can all agree on, and if we can't, then so be it. But would each of you be willing to stipulate, based on what we've heard today and the record and the history and your and your client's experience in this matter, can you stipulate that significant quantities of coal are being routinely spilled by the railroads, and that this causes a number of negative externalities, including the fact that less than 100% of the coal that's paid for actually gets delivered, and other negative things that happen, including what we saw today about the organic farm and those kinds of negative externalities? Can I get a sort of yes or no to that suggested stipulation?
I'd have to say no to that suggested stipulation. I'd be happy to elaborate on that answer.
Please, briefly, which aspect? Not that they're not significant quantities being spilled by the railroads, or that there are not significant negative externalities?
The issue is significant. There's no doubt. Look, let me take the organic farm, okay? Coal that leaves the Powder River Basin travels on average around, I think it's 1,100 miles to its destination. And BNSF has been able to find one organic farmer to complain about the adverse effects of coal being blown off a coal car onto an organic farm. Now, I have great sympathy for the organic farmer and the organic farmer's customers, but that is not a significant problem.
Okay, so I'm clear. You're not prepared to stipulate that there are a range of negative externalities related to routine coal spillage off of railroad cars?
The externalities, I'm not sure whether they're externalities or not, but coal getting into the ballast is a contaminant, and it is something that costs money, railroads money, to deal with.
So it's not a positive externality, but you're not prepared to say that it's a negative externality?
Well, it's a negative, but the question is, what do you do about it?
Okay, so it is a negative, and then do you take issue with the stipulation I proposed about that routinely coal is being spilled out of rail cars?
By various mechanisms, including actions by the railroad.
No, I wasn't getting into causation.
Right.
Okay, thank you. Mr. Sharp, could you take a crack at that? That 2-point stipulation, would you agree that significant quantities of coal are being routinely spilled by the railroads, and that spillage produces a range of negative externalities, including the fact that your company and others don't actually get all the coal they paid for?
Well, I guess part of my concern, Commissioner, is the...
And you don't have to answer. If you say, it's too tough a question or too sensitive, but just yes, no, or can't answer.
Just say very briefly, it gets into what you define as significant. There's certainly some coal leaves the rail cars on its 1,200-mile journey to our power plants.
So we heard earlier say 2,000 tons lost every day. Is that in your business? If you had to report to your colleagues that you had lost 2,000 tons of coal today, would that be significant?
That would depend on how much coal I was shipping that day.
Wow, you're bigger than I thought. I knew you were big, but that's impressive.
This is a hypothetical. We have, over the period of time, we've been shipping coal out of the PRB since 1978. Over this period of time, we have, on several occasions, looked at, is the small amount of coal that leaves the cars in the form of dust or gets shaken out on rough patches or hills or whatever, a problem. Okay, we have compared the weights that we get after the coal is loaded. It's weighed on a scale, and that's the basis on which we pay for the coal. When the coal arrives at our power plant and is offloaded and fed into the plant, it's measured on a belt scale. And then we from time to time perform as accurate an assessment of our coal piles as we can. And we've compared those numbers. We cannot find anywhere that we're losing a significant amount of coal. In fact, in some cases when we've done those studies, we show we received more coal than they shipped us.
That does underscore a worry I have about overloading of coal cars. We'll get to that later. But so you're saying you're not prepared to stipulate that this really is a problem of the spillage, that there is spillage, but whether or not it's a significant problem, you're not ready to say yes to that.
Correct.
That's fair. Mr. LaSure?
We addressed this issue in our filing in terms of how much coal was coming out of the cars. We've heard statements today from the BN about how much they think is coming out. To the best of our knowledge, BN really hasn't done any meaningful studies on this issue. And we pointed out some of the flaws in some of the studies they have used. Utilities keep pretty good track of how much coal they're getting, and some utilities have prepared studies, and we introduced that evidence into the record. I would point specifically to page 16 of Mr. Crowley's rebuttal statement. Unfortunately, all the numbers we have are stamped highly confidential or confidential, so we can't publicly disclose them.
In the interest of time, I didn't mean this to be it really was meant to be a pretty simple yes, no, or can't.
But the answer to your question and how much we think is coming out of the cars is on this page I just read.
Okay, so is it your opinion that this is a problem, a significant problem, or not? In other words, is significant amounts of coal being spilled out of rail cars? And the second part of that is, does that create a range of negative externalities?
If you use BNSF's number of 500 or tons or whatever their number was is significant, then our position would be the amount coming out is not significant based upon the evidence that we put into the the record in terms of an externality. I'm sure I know what the definition of an externality is, but there's no question that we understand that coal dust, along with other things, gets into the ballast. And
Okay, thanks. Mr. Loftus?
We filed the same testimony that Mr. LeSueur has just referred to. It was a joint filing by the two groups, and I would give the same answers.
So it's not clearly a problem, not clearly causing negative externalities.
We certainly don't agree with what BNSF has claimed as the magnitude. And as to the externalities, I myself am a little fuzzy on exactly what they are. And there's certainly, I didn't see any farmers appearing in this case complaining about coal dust on their lands. Now, that's not to say that it's not a problem of some nature, but, you know, I haven't seen anything in the record that's meaningful.
Okay, Mr. Wilcox?
Well, NCTA did not submit any evidence on this. However, I think we would agree that current industry practice allows coal to spill out of rail cars. That's not positive if it's not cleaned up out of the ballast, and the extent to which it extends into negative externalities, I don't think it's, in fact, NCTA doesn't have an opinion on that.
Okay, Mr. McBride?
Mr. Nottingham, a coal shipper, has been following this as we go today. He sent me an email to answer your question. He said that Mr. Fox mentioned that 750 pounds were lost at the high end of the range, which would be 0.3% of 120 tons of lading in the car. What is reasonable to manage 0.3% shrink? So I think the answer to your stipulation is not significant.
Okay, thanks. Have any of, are any of you aware of any requests to the board? I'm not aware of any for the board to mediate this problem. I think the chairman touched on the possibility of alternative dispute resolution. And does anybody just, I guess, say yeah? If you're, I'm not aware of any, but if anyone is aware, speak now, because it just seems to me part of what we have here is obviously a trust issue. That's not a new thing for this board to hear, and it's not trivial, and I don't mean to trivialize it. Trust is incredibly important, especially in business relationships that involve tens and hundreds of millions of dollars a year. But maybe, Mr. McBride, I'll ask you, if we were to have a mediation and we were to get the railroads to sign a proverbial blood oath, enforceable, to be inspected and monitored by neutral experts that your clients could approve of, that the railroads would guarantee that they would maintain all current efforts plus add with inflation or another adjustment, current maintenance efforts along that right-of-way, but they truly are honestly interested in trying to adopt a no-spill and we guarantee the customer that they get what they ordered policy. Would that put us on a path, you think, of some resolution to this?
Well, I don't know about the last part about the you get what you ordered part, because I'm not sure what that would require, but I do want the record to note that I filed a petition for mediation recently in Docket 35302 with BNSF in another matter. So we're perfectly in favor of board mediation when the parties are willing. I've used it in other respects as well. I think it's a highly commendable part of your process. You have to have willing parties. But I think I've indicated that there are members of the groups that I represent who have been part of discussions with the railroads over all these many years on all kinds of PRB matters and on these matters in more recent years. I think those people would much prefer to see a collaborative process than this kind of process. And so I suspect there wouldn't be unanimity on this, but I think there'd be a number of people in the industries that I represent who would applaud you for doing that.
So would you say that if one way or another we or someone could extract an enforceable agreement that would be able to be monitored, that the railroads would not cut back on maintenance along these rail corridors at issue, that would go a long way towards resolving sort of what I'll call the trust problem here?
Yeah, and we'd have to make sure that tariff didn't go into effect on October 1. With those two conditions, I think people would be prepared to have a neutral preside over these discussions and see if we couldn't get somewhere. We haven't had that. We'd welcome that.
Okay. See, Mr. Von Salzen, you mentioned that railroad operations are basically the major cause of I wrote the problem, but I realize you're maybe not quite ready to stipulate that it's a problem, of coal spillage. If it's railroad operations, why don't we hear about other commodities being spilled? Are you saying that railroads operate their trains dramatically differently when they're carrying coal versus when they're carrying other commodities?
I honestly don't know about other commodities. I mean, one of the things I think we have to bear in mind is coal is a commodity that is carried in open-top cars and has been forever.
We are becoming increasingly painfully aware of that. Thank you.
And the same document, the same tariff document that is at issue here on a different page, BNSF requires that the shippers tender them open-top cars. That's the kind of car that has been approved through an AAR process and so forth and so on, far beyond the scope of what AECC and BNSF might agree on. So you start from the proposition that at least for coal, you're going to transport it for good logistical and economic reasons that the whole industry seems to agree with. You're going to transport it in open-top cars. It is inevitable with that technology. You're going to have some loss. You know, you're not going to have a zero spillage standard. You can't meet a zero spillage standard under that approach. You can have a reduced spillage standard. And we're already making substantial progress in that regard with respect to profiling the top of the coal pile, with respect to having better maintenance on the cars themselves so that there aren't seams that coal can or dust can slip out of, so that for bottom dump cars the doors are fitting more tightly, using number 3 coal instead of number 2 coal, bigger.
Right. No, I think I get the gist of your answer.
All
Thanks.
of that is progress towards the goal that you're talking about.
I just wanted to be clear understood, because I think you've helped clarify that it's not just railroad operations. You're not just saying that it's only railroad operations and behavior like speed. I mean, are you basically saying today that the railroads are going too fast, that they need to slow down?
Well, there's certainly on certain locations and certain instances they're clearly going too fast, and there's at least one video in this record that shows that. I mean, you can see it dramatically. And the fact that, and again it's BNSF's evidence, that most of the coal dust in the ballast is on the descending side of big sags has got to reflect the way that the trains are operating in that area. There's no other reason why you would have that pattern of coal deposition along the line.
So it couldn't be the fact that the coal is piled way above the height of the car, and then you're going downhill and the wind blows.
It's not supposed to be piled way above the top. It's just, you know.
Why is it almost every picture we've seen today shows coal piled above the edge of the rail car?
It's not way above. When it's properly profiled, it doesn't. I mean, you know, it's not. The cars that you've seen these pictures of are not. I don't think anybody's claimed any of those cars are overloaded. It's the way those cars are intended to be loaded and intended to be used, so that you get an economic level of product into the car that's been designed by the railroad and power industries acting together.
I want to get to the question of harm. I think it was touched on by Mr. Weichert earlier. Where's the harm here? Have any of you had to pay a fine or had a rail car detained or held back? What's been the injury caused by this tariff? I'll let anybody who would like to speak.
Some of the shippers are paying for surfactants because they've felt some obligation to do that because of the backroom conversations that have gone on. I'm not going to say that they were required to, but I think they felt in order to stay in good graces with the railroad that serves them, that they should cooperate. They haven't necessarily been eager to do so, but they've been spending a fair degree of money to do that. It's, as I've estimated, you saw BN estimated today 20 cents a ton. I've seen estimates higher than that, as much as 25 or 30 cents a ton. But even at 20 cents a ton, you've got people spending millions and millions of dollars for somebody else's benefit. And BN hasn't offered to reimburse those expenses. So that's certainly a harm.
Anybody else want to speak to harm?
Yeah, I would say that at this point the tariff hasn't gone into effect, and so there haven't been any specific compliance costs associated with the tariff itself because it hasn't gone into effect yet. And obviously what our clients are concerned about, among other things, are the costs they are going to have to incur in order to attempt to comply with this tariff. And that's addressed in our testimony, the range of expenses that we think are out there. So I think the other thing that the cost they've incurred is this proceeding, to be quite honest with you.
There's one other thing, Mr. Nottingham.
It was requested by the parties, I suppose.
Well, true, but if you noticed in the video that Mr. Loftus showed, the BN train was not overloaded. That coal was a little above the sill of the car right in the middle as I looked at it, but well below the sill of the car at either end. It was flat at the top, which is clearly a product of the way the car is loaded. And what's happened is I tried to recount for you in the history of this is people were jamming in every ton of coal, every pound of coal they could get in the car back in 2003, 4, 5, even afterwards, you know, because we were well short of coal after those derailments. I'm sure you recall the circumstances. People have cut back. There is less coal going into the cars in order to try to accommodate the profiling. That's an expense that the shippers bear for the most part, because whether they pay for their own equipment and get less use out of it or pay for the railroad's use of the railroad's equipment, they're paying for more turns to get the same coal delivered.
So, Mr. McGraw, do you believe the railroads stand to profit if they can squeeze more coal onto all their rail cars?
I think that's why they did it up until 2005, and then I think they may have realized the error of their ways. And yeah, it would be to everyone's benefit if we could put more coal in the cars now. Ours, theirs, the coal companies. But everybody's learned from the mistakes that led up to 2005, and we're taking the hit. But I don't think the railroads are taking the hit because they end up transporting the same amount of coal in more trains.
Well, yeah, I'm just wondering, maybe that helps me understand why I haven't heard any party today advocate for reducing the volume of coal in each car as a way to get at this problem. It seems that obviously that goes against all the parties' immediate financial interests. However, possibly it could make good public policy, but it doesn't behoove any party here today to actually advocate for that.
Well, not quite. That was true up until 2005. That's what I'm trying to tell you. And even into 2006, when people were desperate to get every pound of coal they could get delivered. But I think today, as I understand it, and some of this is done by the mines, I don't represent them, others here may be able to comment on this, but as I understand it, people have been doing better profiling, reducing the amount of coal in the cars. And I think the video, Mr. Loftus, demonstrated that to you. There wasn't coal sitting on the sills of that car. We can go back to the video if you want to look at it. That car was clean. Whereas I've seen pictures of coal cars with coal on the sills. This is probably back in the 03 to 06 or 07 period when people were jamming in every pound of coal they could. I don't think that's going on anymore. I think people are being somewhat more careful. But do realize that it's still the railroads that demand that these trains be loaded in 4 hours. And inevitably, I'm sure some coal doesn't get into the car. We're, you know, at the mercy of the coal mines and the railroads here. We don't load these trains.
I appreciate the history lesson, Mr. McBride. That was helpful, and I certainly picked up at least a few kernels in there. And I won't go on and on about the history, but there's, of course, a pretty important ICC and STB history related to the joint line, too, right?
Yes.
This is a joint line because of the ICC.
Absolutely.
And we also, in more recent years, the STB actually has approved the construction of a third line called the DM&E. Fought very valiantly in the courts, our lawyers, to prevail over all kinds of arguments, including arguments that the mere concept of moving more coal throughout our society was an inherent evil and should therefore be stopped, that construction should be stopped. But fortunately, we prevailed. So we have a lot at stake here, our agency. We're not just a mere observer, or we have made this line competitive. We have helped make it work to the extent it's worked all these years with the two major railroads operating. We've approved the construction of a third line to go in. And if it takes, in my humble opinion, if it takes a little bit of mediation or involvement by this board to address some of these trust issues, guarantee that the line continues to get maintained, but also ensure that the railroads involved can guarantee that what they promise will be delivered to their customers gets delivered, and that they don't spill the commodity along the way, I think to me that's pretty doable. And hope that we can continue to play a positive role in that regard. I guess that touches on my last question, which is just, Mr. McBride, I'll at the risk of picking on you, but you have a good way of getting to the to answers fairly quickly, so I'll stick with you. If a railroad or just decided to adopt, put aside the safety arguments and I know it's hard to, but if the railroad just wanted to say, look, we're adopting a new business plan / principle that involves two key components. One is no spillage. There's been a lot of negative news out in the world about spillage of energy-related products recently. I can think of a whole host of very reasonable reasons why a business would want to decide to adopt a no spillage policy when it comes to raw energy materials. And on top of that, the second part of the railroad policy could be that they want to guarantee that their customers get as close to 100% as reasonably possible of what they've paid for delivered. And that this no spillage policy goes in that vein as well. It would help me understand how that would be unreasonable. Now, granted, you don't find what I just said in the tariff issue here, so work with me on that. But
well, first of all, remember that the guy who loads the car may be responsible for the spillage. So the tariff would, under your paradigm, arguably extend to the coal mines, and I don't think you have authority over them necessarily here. Maybe you do, but you'd have to work.
I'm saying once it leaves the mine. I mean,
okay, once it leaves the mine, fair enough. I still think that it's unreasonable, but could be worked through in collaborative discussion. And here's why it's unreasonable just to impose it. First of all, as Mr. Von Salzen indicated, the tariff requires open-top cars. The railroads want open-top cars. There's discovery in the record. I don't want to go into it in great detail, but there are some BN internal communications about acknowledging what a disaster it would be if covers were required on cars. Nobody in this industry believes you can put covers on coal cars, because if you've ever been to a power plant to see how the coal's unloaded, particularly in a rotary dump unloader, you can't do it with a cover on the car. It simply won't work.
And I have seen that operation.
Okay, so you know what I'm talking about. So covers won't do it. So even if the coal is below the sill, and recognize that there's an economic disincentive for probably all sides here, the mines, the railroads, and the shippers, to require that the coal be below the sill of the car, because now we're imposing inefficiencies on the most efficient coal loading and handling operation in the world. And I know you've been out there recently and seen it, so I'm sure you know what I'm talking about. And the railroads were the ones that imposed the 4-hour loading requirement. They want this to be efficient. At a certain point, they might be squawking if we could only put, say, 90 tons or 100 tons of coal or 110 tons of coal in a car that now gets 120. Because think about the capacity constraints that might start to produce. So this is a difficult thing to just let one party impose on everybody else and say no spillage. Because incidental loss has always been a product of this. Anybody who's ever walked on a coal line knows that there's a lot of things on that line besides coal dust. And so, again, it's hard to say yes to something that sounds reasonable at first blush, because it's going to impose all kinds of, dare I say, in the presence of Vice Chairman Mulvey, negative externalities.
Thanks. And just I have one last question. You mentioned the spotted mule analogy, and I guess I just would propose for thought. I'm not making a judgment here, but you mentioned the importance in some of our case law, like the Conrail case, of the special train service arguments and line of argument. That could be turned on its face, though, in this case, couldn't it? You got me thinking as you raised that, and it probably wasn't your intention. One could probably argue that for many, many years, the coal industry and the electric utility industry has been the recipient of special train status. You and only you have been able to receive these trains with commodity that falls out of the rail car, opened, uncovered, and loaded above the rim of the car. And after a lot of time and effort and discussion and dialogue and some analysis, the railroads are finally coming around to the point of saying, wow, that special train car service you've been getting all these years, we kind of can't provide it anymore. You're going to be treated like all the other rail customers and be asked to keep your stuff in the car.
First of all, in the special train cases, the ICC found, and the evidence was irrefutable, that the special trains were not safer, so there was no benefit. And I understand you're asking me to hypothesize that there would be a benefit. But one of those many questions I put into my opening pleading was to point out to you that there are a number of other things carried in open-top cars that do escape from the cars. They carry sand and gravel, they carry various ores, they carry soda ash, they carry all kinds of things. And, you know, so ours isn't the only thing that may be leaving a car. But I understand what your frustration is here. You know, if there's a simple economic way to keep something in a car, why wouldn't anybody want to do it? We're paying a lot of money for the coal. We're going to pay more for surfactant than we are for the coal, by the way. But that's what the collaborative efforts that I think people have been working on for years really are best designed to get to. The bottom discharge cars are going to be better maintained. We may do the better profiling. We may get to the point where UP agrees to get people to do mechanical suppression. Some people will voluntarily spray. Maybe the cost of spraying will come down. Maybe all kinds of things will happen. Maybe BN will agree to bear the cost since it's getting the benefit. And all of a sudden, maybe that would change the whole conversation. So I'm not opposed to trying to keep the coal in the car. I'm just suggesting to you that this problem is a lot more complicated than just letting one party impose its way on everybody else.
Thank you. That's all I have for this panel.
Thank you, Commissioner. Vice Chairman Mulvey?
Thank you, Dan. I have a few brief questions. Mike, you mentioned the FRA's assessment of the accidents that occurred back in 2005, yep. And you said they assign blame, they assign cause, and his list of things including maintenance and the like. Did they also mention the coal dust as being at least a contributing problem, or they completely ignored that as part of the problem?
I'm going to ask Mr. Loftus or Mr. Lasser to back me up on this, but I'm relying on the analysis that they put in Appendix B of their opening pleading of the FRA studies. And as I recall, coal dust was not mentioned in those reports.
Is that your recollection also, Mr. Loftus and Mr. Lasser?
It is my recollection, but I wouldn't swear to it because it's a fairly lengthy appendix.
I was also wondering if the NTSB at the time did any investigation of that accident, since it obviously was one that met their threshold of how much in damage, and so the NTSB does investigate some railroad accidents. I was wondering if they investigated that one, because they usually do a very thorough job when they do an accident investigation.
I know they got a lot of information from UP and BN. I believe they also did their own, but I'm not certain of it.
Okay. That'd be worth looking at just to see whether or not they also felt that coal dust was not a contributing factor, or in fact if they did. Might want to note that the board up here consists of 2 lawyers and an economist. None of us are scientists or engineers. And while I appreciate the fact, Mr. Wilcox, that the consultant that you hired did the work, he predated his litigation on this issue, I'm still always concerned about whether or not the results of these kinds of studies are as objective as possible. Commissioner Nottingham mentioned the possibility of the board doing some kind of a mediation on this. Another possibility might be if the shippers as a group and the railroads were to get together and fund somebody like the FRA, or for that matter the TRB or some other group, to do an independent study and to abide by the findings of that independent analysis. Is that something that any of you would be comfortable with? was trying to find out exactly what the numbers are here. On the one hand, the railroads are saying the coal dust is the worst possible ballast foulant. That's a new word, foulant. We learned this time. On the other hand, you're saying that, well, only a small fraction of the coal dust gets into the ballast. Most of it is dispersed. It's not the principal problem. That's one question that might be answered more scientifically than simply warring consultants. Who should pay may be another issue entirely. That may be a policy question. But at least some of the scientific disputes might be resolved through an independent contractor, an independent study paid for by the shippers and the railroads. Anyone comment on that?
Vice Chairman Mulvey, my hesitation was attributable to the fact that I'm here representing clients.
Mm-hmm.
I can't respond to a question like that as to, you know, what my clients would feel because I haven't discussed that with them. So I really, I can't answer.
I guess the Arkansas Electric Cooperative Corporation is probably closest to being a client. Would that kind of thing appeal to you, or as opposed to a trade association, which is? Mm-hmm.
Yeah, as you said, being the only client sitting here at the table, I'll try to address that. But I guess we wouldn't be against considering that. But there again, I mean, it kind of gets into this trust factor. In other words, who would this be that would do this? I mean, we'd have, you know, serious concern about the party. I mean, if it truly could find someone who we would all agree would be objective and would have all of the scientific knowledge needed to not have to just accept information from one party or the other on face value and try to go forward on that kind of basis, we certainly would be interested in looking at that concept.
So can we find an honest man, I suppose, is the question.
Yes.
An honest engineer. Well, I'm not going to speak for my fellow lawyers, but an honest engineer anyway. So, Mr. Van Velsen, you talked about and this was addressed earlier, but I want to follow a little bit more, and that is the BN. You believe that if indeed this tariff was approved, that the result could be perverse, that the BN might actually begin cutting maintenance rather than improving it. But wouldn't that be counterproductive? I mean, if they cut maintenance, I think they admit and they realize how important maintenance is, but if they cut the maintenance and you had an accident, I mean, that affects them, that costs them as well. I mean, it means delays, it means fewer shipments, it costs them money and time if they don't maintain the line adequately, no?
Absolutely correct, but they've done it before. I mean, you know, it may be short-sighted, but it's very clear, I think, particularly if you look at their reply evidence, the testimony of Mr. Sloggett, Mr. Smith, Mr. Van Hook, they are committed to the idea that if they can get the shippers to put surfactants on top of the coal, they can cut back on their maintenance costs. I mean, they don't believe it's going to cause a disaster, but they didn't believe it would cause a disaster when they cut back in the early 2000s either. But we believe that the objective evidence shows that that is indeed what would happen if they cut back on the maintenance. If they didn't cut back on the maintenance, then they wouldn't have any benefit from imposing this tariff on us.
Anybody else? Interesting that BN was the railroad, as somebody mentioned here, when the railroad was under Mr. Krebs, Matt Rose's predecessor, that they kept up their investment in the infrastructure probably as much, if not more, than any other Class 1 railroad. And so it's interesting that you feel they might cut back maintenance.
Vice Chairman Mulvey, I acknowledged that Mr. Krebs was the one who resisted the most when I recounted that history for you, but even he fell behind in the Powder River Basin.
Thank you. What about a trade-off between the cost of surfactant? The railroads allege that these cars lose, on average, 500 pounds of coal for each car, and the amounts were 14,000 rail cars of coal a year. That seems to be a lot of money worth of coal. What about the trade-off between the cost of that coal and keeping that coal in the cars versus the cost of the surfactant, assuming the surfactant would seriously reduce the amount of coal that was lost?
Vice Chairman, there's actually an analysis of that very question in AECC's filing. I believe it's in the rebuttal filing, and it shows that the trade-off between the cost of the surfactant, the amount of coal, you actually lose it. You can't put in quite as much coal in the car because you have to take into account the weight of the surfactant, if you can imagine such a thing. It's so small. And you run it through, it comes out almost an exact wash. You don't get any benefit out of retaining that tiny additional amount of coal. I should say that analysis uses 225 pounds of coal loss, not 500, which is from a study that was put into the record by UP. And the difference between the 225 and the 500 is that the BNSF study failed to take account of the fact that there's water loss during the course of the trip. And so it overstates the amount of coal loss. As Mr. Sharp said earlier, from actual real-world experience, it's kind of hard to find any measurable effect in terms of the actual loss of coal.
Vice Chairman Mulvey, if we can use BNSF's own data from its PowerPoint this morning, using Mr. Fox's average of 500 pounds per car, which I think is too high for the reasons Mr. Salson just indicated. But let's give them their average for purposes of the analysis. That's a quarter of a ton. They said $30 a ton. That's $7.50 worth of coal. They put up a figure of 20 cents per ton for surfactant, 120 tons in a car. That's $24 for surfactant. You spend $24 to save at most $7.50 worth of coal. It's not reasonable.
So the trade-off has been calculated, and the benefit-cost ratio is not a favorable one.
That's why BNSF didn't defend this case on cost-benefit grounds.
There's also the issue of the chemical that's sprayed on, the chemical that's sprayed on the coal, and when you burn chemicals in combination with other materials, carbon materials, there's always a question as to whether or not there's some kind of interaction and whether or not burning coal that's treated with surfactant doesn't have unexpected environmental consequences. Has anybody looked at the problem of burning the coal that's treated with surfactant, or is that pretty much a benign product?
Hello. I raised this issue when we were having some of the discussions in the NCTA study. AECC was one of the utilities that participated in the NCTA study, funded a small portion of that. And I got a call from a couple of surfactant suppliers, and they said, well, what are you talking about? No one's ever raised this issue. I said, well, okay, what chemicals are in your surfactant? And they said, well, that's proprietary. We can't tell you.
Along with the model.
Exactly. So I said, well, okay, how do we know that that's not going to react in the boiler? I mean, it's a very complicated chemical situation and all going on in a boiler. No one has to date been able to correctly model that. You model it the best you can, but almost every time we try something new, we get a result different than the models indicate. So the real answer is, from all that we've been able to ascertain, is no one knows. There may be negative externalities. It may affect our pollution control equipment. It may affect the metal in the boiler. We just don't know.
We always get surprised. I mean, just this morning it was announced that McDonald's was recalling all of these glasses because while they were considered to be products as opposed to be gifts for children, it turns out that they do contain some very serious metals, which if they in the washing machine would begin to get loose, could in fact cause serious harm to children. So we keep finding out that more and more what we do is not so benign as we may think. I noticed that you were talking about some of the problems with why the coal comes out above and beyond this airborne dust from the rattling and the shaking, et cetera, and why it concentrates in certain places where you're able to get more rattling and shaking. And especially you mentioned the train going too fast, going downhill, and while I appreciate that lately there's been some increased capacity available because of the turn down of the economy, nonetheless, I believe your company in particular has complained about the failure of the railroads to deliver all the coal that was needed. And wouldn't reducing train speeds actually cut capacity out of the PRB and create another set of problems? I mean, getting those trains moving even downhill as fast as possible strikes me as something the coal companies and the utilities would like.
I haven't seen an analysis. That's obviously an issue that would have to be looked at. But just on the face of it, I don't see that it's necessary that the overall trip time should be materially impacted by simply slowing the train down on the downslope for 10 miles an hour, whatever it would take. And you have to do an aerodynamic study, I think, to figure out how much you'd have to do that. What it might do is increase the railroad's fuel costs, because then you'd have to you need more power going up the upslope. I think the reason this is speculation, but I think the reason they speed down the downslope is the same reason you might do it with your car, to save a little bit of gas on the upslope, and that might be one of the countervailing costs for the railroad in reducing the amount of coal dust on the downsides of the big sags. But that's speculation. I
guess they can't throw it in neutral and just coast down there. Well, it's an interesting to speculate on, because the fact of the matter is it's a well-used corridor, very, very heavily traveled, and just adding extra time for each train when you've got 70 trains, 120 cars long with the required spacing distance that they have, it could in fact cut into capacity. So that would be a concern that I think the railroads might have if they're talking about trying to save. You also suggested that spraying surfactant would not reduce any of the coal loss from just rattling. Do you want to explain that a little further? Because it would strike me that a surfactant, being a sticky material, might effectively reduce both the airborne dust wind caused as well as the lost coal from shaking.
I understand it, and there is evidence about this in the record, so I'm not trying to tell you what, because I'm a lawyer and I don't know anything about physics or anything like that, but my understanding is that the surfactants that they're talking about put a very thin crust on the top of the coal pile in the car that is supposed to be sufficient to keep very light dust particles from being blown out by wind, either the wind of passage of the train or actual wind going across laterally across the track. But we're talking often, particularly when you're talking about slack action on these downslopes, we're talking about actual pieces of coal, not necessarily a whole lump, but real pieces of coal, and they're too big to be held down by this thin layer of crust, as I understand it.
Anybody else?
Yes, I've had people tell me that there's been a problem in the past with the railroads maintaining some of the bottom discharge cars and the doors, and I think the vibrations may cause some of that coal to come out of poorly maintained doors. Hopefully they're on to doing better maintenance there, but it's interesting that they proposed to put surfactant on the top of the car. They didn't propose to do anything about the bottom discharge when they're the ones that own those cars.
The cars that are bottom discharge cars are basically railroad-owned cars.
Correct.
Because most of your cars now are okay.
Open top.
Open top and thank you. That's all I have.
Thank you very much, Vice Chairman, and thank you very much, panel, for your help today. And we will call our final panel, panel 4. So Arkansas Electric Cooperative, you can stay up front. As long as you two can behave yourselves up there together, BNSF and Arkansas Electric. It doesn't really matter. I'm sure they want to sit next to each other, but...
Not always.
Next up, yeah, I'm sorry. Next up, we'll have BNSF on rebuttal. You have 10 minutes.
Thank you, Chairman. A lot of things have been raised. We're going to try to focus on the big picture initially with whatever time we have. We've made a massive record. The shippers seem to say either this last panel, it's really not happening, or it's not a problem, or it's all about the cost, the shifting of cleaning it up, the money. For us, it's not about that. It's about the integrity of the railroad, service and reliability, and the need to reliably supply those stockpiles and do the right thing and keep the coal in the cars. But initially, we've got a lot of things we could address, but initially we will address some of what I find that, frankly, the most obnoxious and offensive accusations in this last panel about our railroad and our maintenance practices and how we maintain and plan to maintain this vital national asset, which we take with the utmost seriousness. This is not just shifting around minuscule amounts of cost. This is about a vital national asset. So we'll defer first to Mr. Fox to address some of these operating accusations, and then whatever time's left or on Q&A, we raise a lot of other things, but we think we start there.
Well, first off, on the maintenance issue, the joint line is absolutely maintained at very high levels, world-class levels. We utilize the best railroad technology available. We utilize the best equipment available, and we've got the best people available to do that. Our maintenance is condition-based, and when you've got a 400 million gross ton railroad like the joint line, we will always have a high level of track maintenance on the joint line. We take that responsibility very seriously. That's why we're here today. At the end of the day, this is all about eliminating the release of one of the worst fouling agents, coal dust. To infer that our purpose here today is to reduce track maintenance is absolutely wrong, and it's frankly, it's insulting. In terms of the discussion around airborne dust is the issue, it's all about coal falling off due to changes in track modulus, its switches and bridges and slack action. Well, with the right load profile, the profile we talk about is a bread loaf, that has the right angle of repose in terms of how the coal is loaded. The coal will not fall off the car. In fact, it should not fall off unless it's on the sill of the car, which would be in violation of our activity-based profile standard. Also, from a car design perspective, we talked about bottom dump cars. Bottom dump cars are 35% of the fleet. And we found through field tests that releases through the bottom dump cars on average was around 35 pounds. That is not the issue. Majority of the cars on the joint line, 65% are rotary dump, and stuff doesn't fall out of rotary dump cars as they traverse switches and track modulus at bridges. Finally, we're in the midst of doing a field test as we speak with additional topper technology, and in this case we've treated cars with toppers, and then we've put on train monitoring devices that are hung on the cars. We found that topper in that application can reduce dust by 92%. That's measured on the train, it's not measured trackside. So clearly, airborne dust is the issue here. It's not an issue of dust falling due to track modulus and slack action. Finally, with regards to running our trains faster downhill, it's a ridiculous accusation. We do not have an operating practice of running trains faster downhill than uphill. At the end of the day, our train engineers are very well trained, and we have a very robust electronic oversight process of train handling as well as speed compliance. That goes on 24 hours a day, 365 days a year, and we utilize our version of a black box on every locomotive to do that kind of monitoring.
Couple of basic points. We think the core principle here is it's not all right for the coal to spill out of the cars. The solution isn't to clean it up. Mr. McBride's suggestion referring to the old cases on special handling, it's not okay for nuclear materials to leak. It's not okay for chemicals to leak. It's not okay for coal to spill out. We have to do what we can within the realm of science to advance this. The surfactants are not an unproven technology. Things will get better, but the rule should not be delayed. The rule should go into effect. We have been working cooperatively with shippers. We will continue to do that. Solutions need to be jointly found, but it is time to act, not to defer the problem, not to defer it as some sort of stall to put this off into the future. We do have an obligation to move forward from BNSF's standpoint and put into effect a rule that keeps the coal in the cars, that uses the best standards we have available today, not to delay. It's not okay to pick it up. It wouldn't be okay for BP to pick up that oil faster. It's not okay. We now know much more about ballast than we did 100 years ago. We know much more about coal dust. You heard DOT today say it has a pernicious effect. I don't think that should be seriously in dispute. Whatever the parties before were willing to stipulate to got a little confusing to me, but we will stipulate that coal ballast is a pernicious effect that should not go there in the first place. Therefore, we think it is time to move forward to put this rule in and not delay it further. Yeah, go ahead. Cover that one. Excuse me.
I would like to address an issue that several of the members here this morning and this afternoon have expressed interest in, and that is, what possibility is there that we can reach a, let's call it a negotiated resolution of the issues presented in this hearing. The process that BNSF envisages, and I believe from what I heard from Ms. Rinn, that UP envisages as well, is a process of voluntary bilateral negotiations, discussions, and arrangements between the railroads and their individual customers, as opposed to, let's say, one big kumbaya under the auspices of a mediator. And there are a couple of very compelling practical reasons why it has to be done that way. First, we have a majority of customers of both railroads are contract customers. The contracts, as you know, are typically of multiple years in duration, and they expire at various times. We have to deal with contract customers on the coal dust issue as the contracts expire. Because they're contracts also, they're privately negotiated between the railroad and the particular customer. So it's really got to be a sequence of bilateral negotiations for that compelling commercial reason. Second, there's a compelling legal reason why it has to be a sequence of bilateral negotiations. And that is, BNSF and UP are competitors on the joint line. We share the facility, but we compete vigorously for a lot of the traffic, which, by the way, is one of the reasons Mr. McBride's gratuitous characterization of the railroad as a monopolist is hogwash. We compete vigorously for a lot of this traffic, and we're not going to get in a room together with UP and the coal shippers and talk about a comprehensive solution to coal dust that entails commercial considerations. Can't do it. I mean, one could imagine, I suppose, a proceeding that got prior antitrust risk clearance from this agency and DOJ, but, I don't see that happening. From the beginning, BNSF has envisaged a process in which we get to the point of resolving this dispute, of resolving the coal dust issue as soon as practicable by working with the individual shippers as the opportunity arises. The only way we're going to be able to get the shippers to agree to do something about the coal dust issue is if this board says We have the right to adopt rules that prevent the shippers from dropping the coal dust on the right-of-way. They have to believe we have the right to do what we're trying to do, or they're not going to sit down and talk with us. They're going to play rope-a-dope. And if you go back and look at their pleadings in this hearing, about 90% of what they've done here is one version or another of rope-a-dope. We don't want any more rope-a-dope. We want to move forward.
This whole argument about cost shifting is not what's really going on here. Time to implement a rule. We respect the board's jurisdiction on the enforcement issues to come back if something can be challenged there. But the rule that says the coal should stay in the car like every other commodity should go into effect.
Thank you very much, BNSF, and why don't we finish with Arkansas Electric Cooperative. Mr. Von Salzen, you have 10 minutes on rebuttal. We've got to give him a mic.
Thank you. I will try during my 10 minutes not to be any more obnoxious than necessary, any more insulting than necessary. I will try not to make any ridiculous arguments. I think approaching this issue with that kind of overheated rhetoric is probably symptomatic of the problem that we're facing here. There's a huge record in this case. I've given you some highlights of it in my 23 minutes of fame earlier this afternoon. That's what I've told you is about evidence. It's evidence in the record. Much of it is based on facts provided by BNSF, almost necessarily, because they're the ones who have control over the facts about the joint line. It's their property that they operate. So we've had to get the facts, the data from them. We've analyzed it. It is in the record. It's very well to say, it's ridiculous to say that coal dust falls out of trains because we're running them down hill and causing slack action. It may be ridiculous, but it's a fact, and the evidence is in the record. I think BNSF may be hoping that the board will not read the record, but I have confidence, because I know this board, that you will do so. It is not ridiculous. It is true. I also would like to take issue and umbrage at the suggestion that the coal shipper community is so narrow-minded, short-sighted, selfish, and stupid that the only way that they can see reason is if you give BNSF the power to force the shippers to do what BNSF wants them to do. Mr. Sharp made very clear in his remarks, and I'll just second them, the coal shipper community has invested hundreds of millions of dollars to improve the efficiency of coal rail transportation. These are not people who are sitting back on their hands being negative. We have legitimate disagreements with BNSF's theory of how things work and what to do about them. Saying that the only way to make us act reasonably is to give BNSF a club to beat us over our heads perhaps sounds good to them. It doesn't sound very reasonable to me. Mr. Fox tells you that BNSF is maintained to world-class standards, and it's insulting to suggest otherwise. As a matter of fact, what we've said throughout this case is that BNSF is maintaining their railroad adequately. I wouldn't say world-class standards. We've had some criticisms of some of their aspects of maintenance over the last 5 years, but they have been maintaining their railroad, and we think in a generally satisfactory manner. Hope that's not an insult. But bear in mind, this same railroad tells you that they were well maintaining their railroad all the way up until May 2005. That's in the record too. In fact, this railroad tells you that given what they knew, they did nothing wrong. 2 coal trains derailed within a few minutes and a few miles of each other, and BNSF tells you on the record under oath in this case they did nothing wrong. I think you have to look at the evidence. I think you have to look at the facts in this case and not just listen to the rhetoric, including my rhetoric, by the way. I'm not asking you to be swayed by my golden-tongued oratory. But the facts are the shippers don't cause this problem. The railroad causes this problem. I was trying to avoid using the word problem, as Commissioner Nottingham noted. I should probably call it an issue. But sure, there is a maintenance issue, there's a maintenance challenge that has to be carried out when you have the huge volume of traffic on this rail line. Coal dust is one of the contaminants. It is, according to the record, 29% by volume of the contaminants in the ballast on the joint line. That's what we've been talking about. It's 29%. That leaves, if my math is right, 71% of the contaminants in that ballast we're not even talking about today. And most of that coal dust does not get on that ballast through being blown by the winds off the tops of coal cars. It gets in there through the other mechanisms that we've talked about today and that are well documented in the record. Thank you.
Thank you, Mr. Von Sausen. Do you have any questions?
Just a couple of minor questions. To the railroads, Mr. McBride testified, and he was seconded by others, Mr. Loftus, about the FRA's study of the 2005 accident, and he said that the FRA found that the accident was caused by maintenance issues and others, but that they never mentioned coal dust as being part of the problem. Do you want to comment on that? Is that your recollection of the FRA report as well?
I'll answer a question as well that you didn't ask. And did the NTSB investigate? No.
Yeah, that was the other part.
They did not do a formal investigation.
They did not, okay.
The FRA obviously did an investigation, and at the end of the day, I do not recall if they concluded that coal dust was a contributing factor.
Okay. Shippers presented evidence in their filings that they monitored some trains, and that some trains went by full of coal trains, unit coal trains, and there was virtually no coal dust coming from them, and other trains went by and there was a lot of recorded foulings, and that the common factor was a locomotive as opposed to the fact that it was coal trains. Do you want to address that charge, that it's not necessarily the coal dust, but it's actually perhaps emissions coming from the locomotives?
Coal dust is clearly episodic. I believe that is the term Mr. Sipe used earlier this morning. But our tests clearly differentiated, and that's the difference between the first and second standard, the effects of coal dust and then the effects of locomotives. Frankly, the idea that all this is coming out of the locomotive seems a little preposterous as well.
There's a specific diesel signal, and the IDV2 value ignores that diesel signal for the locomotives at the front of the train, as well as the distributed power at the rear of the train. That is not included in the IDV values.
Is it possible that some of the coal dust that gets in the ballast doesn't come from the top of the train immediately onto the ballast, but rather goes off to the side and then subsequent winds blow it back and the ballast simply begins trapping all of this coal dust, and that it's part of a cycle when with the raised ballast, especially in a relatively flat area like the Wyoming, Kansas, etc., you wind up having the winds blow it into the ballast, and that's where it's being deposited, as opposed to directly off the top of trains?
It's definitely possible. that coal dust gets in that way, as well as from the top of the cars, as well as from the bottom dump. We still believe that the majority is coming off the top of the cars.
Would you agree with that, Mr. Van Salten, that in fact some of this coal dust could be in the ballast, even though it's not coming off directly, it eventually gets blown back by the winds, and given that the railroad right-of-way is the major mountain, if you like, going across some of these very, very flat territories, it still gets in the ballast, but maybe it's not directly from the top of the train, but it gets blown back.
I don't believe there's any evidence in the record that would support that speculation. It's possible. I mean, anything is possible, but I don't believe there's any evidence that that is indeed the case. I guess I would be skeptical about it, just because I think I'm imagining just a breeze blowing through the buffalo grass, picking up dust and blowing it back towards the track. I have a hard time imagining you get very much movement that way, but it's possible.
Vice Chairman Mulvey, I have a recollection, perhaps faulty, but if you look at UP's opening evidence, I think there's testimony that speaks, if not to that very specific issue, at least to closely related issues about how dust that is dropped, particularly on a multi-track segment of the joint line, works its way into ballast, not necessarily directly.
And we, of course, welcome deep review by the board and staff that we know will be taking place of the record, contrary to the assertion.
This, again, is one of these matters of fact and matters of sometimes scientific fact and how things behave in the environment. And as I said, either the board members or most of our staff or most of the people who are testifying here really possess that kind of expertise. I asked the question of the last panel as to whether or not they thought that their members or the groups would be interested in co-sponsoring, co-paying for a study, perhaps even overseen by the board, which it did employ, however, people who were noted experts, but they were not in the pay of either the shippers or the railroads, to answer some of these scientific questions. I recognize that these are contracts, et cetera, and you have to eventually decide, but at least a lot of these scientific questions might be answered in such a way that both parties could accept, well, this in fact is what is happening. For the railroads, will the railroads be in favor of or support such a possibility?
We will work with anyone, talk with anyone. We have been doing that. We've been spending money on this for the last 3 or 4 years. We think we have to move forward. We believe we are responsible to address this problem through the promulgation of an operating rule. We do not think that we should wait. We do not, however, expect to stop looking at the scientific issues. Expect to stop looking at the best way to address it. We do not want to participate in something that tries to deny the problem. We want to look for solutions. We're doing that. We think there are solutions that are there today. I think it's a question of working with others on continuous improvement, not refusing to move forward.
Right. Well, it's not denying the problem. It's trying to define the problem, identify the problem, and then what would be the best possible solutions that are both cost effective and environmentally effective. But mediation. I understand that mediation. There was some concerns about mediation, but this would not be mediation, and this would simply be a resolution, if you like, of the scientific disputes, which I think can be done with some degree of objectivity, albeit there might still be some issues that will remain unresolved for whatever reason.
One potential benefit of the safe harbor approach that was discussed this morning is that we could begin solving the problem right now under a safe harbor approach and continue to work on the science and get it better. So down the road there was a standard, a performance-based standard that everybody could be comfortable with. But I can't think of any reason why that would preclude taking measures in the near term under a safe harbor type approach.
A safe harbor approach. Under that approach, then the shippers would not have to pay a tariff. In fact, if they agreed to use suffocants, if they agreed to profile the cause in such a way to minimize, then that would be considered to be acceptable, and therefore they would not have to pay the extra tariff.
But we're not asking for. We don't want to collect money. We're not asking for a tariff. We're asking for implementation to begin on surfactant or whatever method the shipper chooses. But the safe harbor concept was if they want to, and people are doing this now, and that's why we need a rule to make sure that this momentum continues. Remember, we're only talking about, frankly, in terms of jurisdiction, a small segment of the shipper population that the rule directly applies to, but that the rule should be there, and we are quite open with the suggestion you and the chairman were airing out earlier today, that there could be a safe harbor, that if they are applying this, taking this step that we know addresses the problem, whether it's the only way or the perfect way, we are not precluding other ways under the performance-based. We would recognize that as a safe harbor, and science could continue to develop, and we think that will get the process going of these companies working together, finding the most cost-effective, efficient way to reduce the dust. We think reducing the dust is where this has got to come from, and the coal staying in the cars.
One final question to the group. What if the safe harbor is then, is that the metrics-based safe harbor, or it's not the metrics-based safe harbor, it's basically that they spray the surfactant and they profile the cars as directed. But if they do that and you still get unacceptable readings, then do you simply raise the requirements, require more surfactant be sprayed, or require that the cars be profiled even lower?
I don't think so, and this is a bit of an inchoate idea that sounds like we're working it out, or it's being discussed today, and we had thought about this kind of thing in the original. What I think we envision, or what we thought we heard, or what we are open to is, we have published a performance-based rule that says meet this standard, and because we believe that standard reduces 85% of the dust. We are open to amending that rule and working with our shippers that there would be a presumption if you applied the known surfactants. You pick which one. If you want to tell them, these tests are all around here, what would work, that will presumptively, in our mind, meet compliance with the performance-based standard, regardless of what the readings say, or regardless. We do that for 2 or 3 years, and let's see if everything is working together. We know we must do something, and we know it's being used around the world and this country, that this is not an untried thing. Let's get going on it, and we will be willing to say that is a safe harbor that meets our performance-based standard. I think at least that's what we heard and what we're open to.
Thank you very much.
Thank you, Vice Chairman. Commissioner?
Thank you, Mr. Chairman. Mr. Fox, I heard you make the point that with the right load profile, spills can be prevented. Is that a fair restatement?
Yes, sir.
Have there been any studies on that, or any data, and would, under the general sort of heading of correct or right load profile, what about the scenario I've described today earlier about keeping the profile below the rim of the rail car?
Yeah, over the last 5 years, we have modified the profile. The initial profile was what I'd call a peaked profile with sharp edges. And with work with NCTA early on, 4 or 5 years ago, we created what we describe as a bread loaf profile. It's we lowered the angle of repose of the coal on top of the car. We got rid of the sharp edges, which reduces wind erosion, and we spread the load all the way from the front of the car to the back of the car. That is the standard that's in place now on the joint line. All chutes in the joint line, all loading chutes in the joint line now have been modified to create a bread loaf profile. We have not looked at what I would describe as the bunt cake option, where you would load coal below the side sills of the car.
Can I ask why you wouldn't look at that?
Well, we haven't done it, and we did have some concerns based on some very preliminary discussions with our consultant that the concern was an eddy current could be created where the wind would start an eddy current at the front of the car and basically continue causing wind erosion with that kind of loading profile. But that was really preliminary discussions.
Mr. Weichert, would you be open to an alternative safe harbor, which would be either try the surfactant or whatever turns out to be the best practice. You believe, I guess, currently it's surfactant, and you've held open the possibility that in the future with technology and science we could see other solutions. How about an alternative safe harbor? If you're not comfortable, shipper, with the cost or the science behind surfactant, just keep your load profile below the rim of the rail car, so we have a greatly reduced potential for spillage.
We probably need to distinguish. I believe our testing has shown that the profile and the profile improvements may have reduced 10 or 15% of the dust issue, and subject to the type of technical problems and the physical problems Greg Fox has related to, it does not appear at all that can address the overall problem. Having said that, if a shipper or a mine thinks a different technique can reduce and meet the standard, we're quite open to that. I don't think, on the contrary, the testing we've seen, and the several years of work on this would not support a safe harbor based just on profiling. It can't do it. Everything we've seen and what we've been doing, it's not sufficient, and that doesn't work. Whereas now several years of testing shows no, surfactant can do it. It can make a dramatic reduction in magnetic, and that's a technique being followed in other parts of the world.
So are you saying that the railroad industry has, or anyone else has thoroughly studied the scenario of having a load limit be, or a safe harbor be below the height of the rail car?
I cannot address as a technical matter whether that completely exhausts it, but of course that also, if we talk about profound impacts on our customers and the industry, now we're talking about more equipment, more trains. How do we meet the commitments we have and their desires to keep those stockpiles full? Because now we start talking about a dramatic difference in how much coal is handled. If that were, in theory, cost effective and shippers wanted to go that way, we're open to exploring that. But within the existing way the railroad and our customers and these fleets and these hundreds of sets of equipment are running, we don't think that's a way that can address this, certainly not in any foreseeable time.
We've heard the argument raised today that the railroad should not be allowed to unilaterally impose a solution on the customers. Can you think of any examples in the past where, after efforts to dialogue and communicate, the railroad industry has had to impose a solution in the area of car design over the objection of some shippers?
Well, for better or worse, the way our world works, and I don't mean, I guess, just the railroad work, the railroad owner, the person offering the service, always ends up being the one, hopefully, as in this case, after consultation with their customers, hopefully, as not entirely in this case, after agreement with their customers, has to set the terms of carriage. We have massive, and some people would say too massive, we've been trying to get more of the plain speaking thing, but the rule book on coal, the rule book on grain, the rule book on commodities. There are, as were mentioned earlier, a variety of AAR and industry rules which generally apply, but then every railroad for every commodity. We've got blocking and bracing rules for all kinds of stuff.
And is it pretty common for some shippers to object to those rules as they come along?
It does, unfortunately, occur, perhaps more often than we would like.
Okay. Is it your position that a railroad cannot be required to transport leaking cars?
I think I'd have to say yes.
It can choose to, right?
It can choose to,
but it can't be required.
It has to ultimately has the responsibility to define the terms under which things are loaded and braced, and we do not believe it can be required. Leaking is a loaded word, but yes, if something's really leaking, we cannot. In fact, I guess I would turn it around in the proper situation. Chemicals are always easy, but a dangerous load of rebars or something, we may have an obligation not to transport it.
It seems to me if there is routine spillage, release, leakage, pick your favorite word, that basically that's tantamount to routine overloading. And it seems to me a railroad has in my humble opinion, the right to say we're not going to take cars that are routinely overloaded and that therefore routinely leak. And you put that out for a reasonable period of time, and you give people the safe harbor alternative course of action. And I'm just speaking as one board member. I think this agency, I would think, would be hard pressed to say that a railroad is required to move leaking freight cars.
Leaving aside a pure safety issue, which is the absolute on the railroad, meeting both FRA and our own requirements, I will use my analogy. It's not the same, but in the stages of things, we have all kinds of rules of how heavily cars can be loaded, including on coal. We have corresponding tariff items, which you do not have before you now in this case, which says if something violates that and it's overloaded, what we do. In that case, depending on exactly what it is, we say we will set it out and we will get a dumpster and unload it something, and there are charges for that, and that's all set out, either in a contract or in a tariff. Were someone to be subject to that, and were that to occur, we recognize as to the common carrier shipper, that's within your jurisdiction. And that is certainly, we believe, within our ability as a railroad to do that step. That's not before the board here. What before the board here is keep the coal in the cars, reduce the dust.
Do you recognize that it may not be the intended outgrowth of this controversy, but one possible outgrowth is that coal cars are required to move with less coal? It's out there in the range of possibilities depending how this controversy plays out.
It certainly is a possibility, but we think it's pretty remote, particularly when, for all the talk about cost, when you look at the overall delivered cost of coal, this is such a manageable, doable thing as the most cost-effective way to reliably move all this coal across the nation for all this energy within the existing fleet. However, that's why we started with a performance-based standard, not an activity-based standard. We're open to a safe harbor for an activity of spraying, but between the shippers and the mines, if there's a better way to achieve the result of no dust that's more efficient, we're not precluding that.
And I guess Mr. Sipe, you may be the best person to handle. Do you find it seems to me that you're in the untenable legal situation of being tempted to make the following type of argument. The better you can argue about how hazardous, dangerous, risky, negative, scary, throw in your risky, the movement of these heavily loaded, I'll say, I won't editorialize and say overloaded, but these heavily loaded cars of coal that seem to routinely spill out coal, that you seem to say a significant amount of coal. The better you argue the risks and the hazards and the negative externalities, the more actually you're inviting third-party litigation by the organic farmers of the world that your client so skillfully demonstrated to us. So I mean, do you see it? Do you feel any tension there, or is that?
I'm not sure I'd subscribe to the characterization untenable, but you've seen the record, and you know we have not gone on and on about environmental risks and concerns. But everybody knows what the reality is. We live in a world where there's a lot of attention.
And one could suggest that this tension is another reason why we as a responsible railroad need to put into effect a rule to mitigate coal dust.
That's why I asked the question, because we don't have a lot of third parties before us here, but many of us were, I think actually this may be a situation where almost most of the parties that were testifying today actually were, and including the board, were basically aligned on the DM&E appeal and the battle. We heard some legal arguments, very serious legal arguments raised by serious lawyers spending tens and hundreds of thousands of dollars, not millions, to recite a litany of, I'll just use the phrase again, negative externalities, but basically horrible attributes of coal and coal-related energy production. And so, I mean, we're all very mindful. This is not just some kind of contrived concern. Are any of you, Mr. Slipe, are you familiar with court cases where parties have tried to raise claims about various hazards and dangers of coal and coal transportation?
Well, I'm certainly generally aware of what happened in DM&E. I know there's litigation currently in Alaska, which I believe involves stockpiles in a port in Alaska. I think these issues are potentially out there, and you're probably correct in inferring that we haven't gone out of our way to stir people up.
Right. And I think this board, the reason I go into this is not to give you a hard time or to conjure up alarming scenarios, but this board has a number of missions, I should say, some of which include promoting competition, working to review and approve where appropriate construction and new build out and new track. And so we have an interest if there is a commodity that is spilling out on railroad right away and basically inviting third-party opposition to projects that would increase rail competition. It's more than an academic concern to us. And so I guess I would say, wish you luck in trying to take steps to stop commodities from leaking out of your cars. I think I understand why you're trying to do it. I may have some concerns with the methodology you took or the tactics you took in this case, but I think certainly, in my humble opinion, you seem to have the right to try to control spillage out of your rail cars.
Commissioner, if I could comment briefly on that. There's almost some role reversals here. We have people saying this is too tight a rule to keep an emission down. If there were some analogies early in the day to government-induced rules, the usual question is, you're not being strict enough, whoever's trying to control emission. Here we have people saying, don't worry about it, let it blow off, let it happen. That is not our position. It's time to do an incremental approach to reduce this problem.
I have no more questions with the panel. Thank you.
Thank you, Commissioner. I just had one line of questions from BNSF. I heard earlier in the testimony with regard to customers under contract. Is there a significant percentage of the coal traffic in the PRB that's on the joint line that is under contract at this point in time?
Yes, Chairman. I will speak generally, I don't
want to go to confidential information, obviously.
I'm speaking only, of course, for BNSF Railway. Very roughly, I would estimate in the range of 80 to 85% of the tonnage we move in the PRB, it moves under contract. Somewhere in the 15-20% moves under common carrier tariffs directly subject to your jurisdiction, including the rate case stuff. By the same token, I made an allusion earlier today, and I think this is important, understanding who's subjected to what and who's will this rule go into effect. Our general estimates are that by the end of 2011, something in the order of 65-70% of our contract tonnage will be, by however it works through tariff, contract version or other, will be subject to such a rule as we are proposing here for the common carrier shippers and asking that be upheld as reasonable.
So if I understand what you're saying, at the present time you have the 80 to 85% under contract, and they won't be subject to, to have the surfactants on it at the present time?
Again, so it's the rule for a performance-based, some of which are, of course, choosing to go the surfactant route. Some are already there where the rule is in effect and we're working on implementation, but a large chunk of that contract base is not yet, will be by the end of 2011. As contracts roll over, as they are negotiated, older contracts before this problem arose that, to speak generally, might have incorporated an older version of rules might not yet be subject to the rules application today, but will be in due course.
So incrementally, have you been putting things like this in contracts?
Again, without getting into the specifics of course. Okay. We are working on implementing this through our contracts as well as quickly as we can as things turn over, as things come up. This is a gradual, somewhat lumpy process, but it is moving along.
And say that tomorrow this is obviously very hypothetical because we can't issue a decision one day, but we said that it was reasonable. What percent of the traffic would you say would be required at that point to run based on the tariff, or something similar?
If you permit, as we ask you to do, that this rule go into effect on October 1, then at that time, directly that 15% or so of tariff traffic would become subject to it. Again, remembering that the rule is not saying you must go spray, it is not asking for instant compliance, it's asking you to be working with some of that contract base. You raise some very interesting technical issues because quite frankly, it doesn't necessarily depend on whether you uphold the rule or not. It depends what's in the contract and what the contract is incorporating and what the contract says about a rule. But we will be continuing to move towards broader and broader coverage through a combination of that tariff application, its incorporation in our contracts. I don't mean to overcomplicate it, but it's an iterative process.
Yeah, my only concern there was similar to the concern I had earlier when I was asking you about Union Pacific and how they are going to go forward from here, is that there'll be trains running around the joint line and there'll be coal flying off, and while this 15% will be subject to the tariff, and I guess coming to the conclusion that it may not be effective, and that would be my only concern.
I will, of course, not speak to UP's practices. I don't know what they are. I heard Councilor Luanren speak to it earlier today. Our relationship with UP on this operating rule, now I'm speaking of the pure operating rule we put up on the board, comes about between us and UP under the joint line agreement, which contains its own series of enforcement mechanism, arbitration remedies. It's an operating rule as soon as practicable, recognizing the realities of this rather convoluted or multi-tiered situation, which we respect because it goes back to the ICC-approved joint line operation of the two carriers, with us as the maintaining and operating rules carrier issuing the rules under that agreement. But as to our customers, we've tried to describe generally this iterative process of bringing these into broader and broader effect. I have to say, if the rule doesn't go in on the common carrier, that will be a step backward, a detrimental step to the gradual incorporation and working with our customers, because not only will it delay things, but it will call into question whether this can be seriously applied to the universe of shippers. It should eventually, over time, be applicable to.
Thank you very much, Mr. Weicker. Thank you, Council. Thank you, everyone, today for your patience. It was quite a lengthy hearing, and a special thanks to the officers that came here today. Your knowledge is invaluable, and we obviously take this matter very seriously. We can tell that it's a very emotional issue, and we'll take it under advisement, and the hearing is now adjourned. Thank you.